Okay. Ms. Semino, we're on Zoom, or I mean on YouTube, we're all set? Oh, you're muted, Ellie.
Yeah, we're live streaming.
Okay, thank you. Well, good morning, everyone. Today
Morning.
is Friday, February 18th. This is a meeting of the Criminal Justice Public Safety Committee. And I'll begin straight away to have everyone introduce themselves. First of all, I'm Senator Susan DeChambeau from District 32. I represent my hometown of Biddeford and the surrounding towns of Dayton, Lyman, Alfred, Arundel, and Kennebunkport. And I will begin with House Chair Representative Warren.
Thank you, Senator. Good morning, everyone. My name is Charlotte Warren, and I represent the towns of Manchester and West Gardner and the city where I live of Hollowell. Thank you.
Okay. Senator Searway.
Good morning. I'm Senator Scott Searway and represent District 16, which covers Waterville, Winslow, Fairfield, Benton, Albion, Clinton, and Unity Township.
Thank you. And Representative Pickett.
Morning, Senator. My name is Dick Pickett. I represent House District 116, the towns of Mexico, Dixfield, Peru, Canton, and Hartford.
Thank you. And Representative Morales.
Thank you, Senator. Good morning. My name is Victoria Morales, and I represent District 33 in the west end of South Portland.
Thank you. And Representative Rudnicki.
Thank you, Madam Chair. I am Shelley Rudnicki. I represent House District 108, which is Fairfield, Mercer, and Smithfield. I hope everyone has a happy Friday.
Thank you. And a holiday coming up too. Okay, Representative Fluker.
Thank you, Madam Chair. My name is Bill Pluker. I represent House District 95, which is Warren, Hope, Appleton, and part of Union.
Thank you. Representative Lookner.
Morning. Thank you, Madam Chair. My name is Grayson Lookner. I represent District 37 as part of Portland, out by the airport and the Fort River.
Thank you. Representative Newman, are you still with us? Okay. Representative Newman is on a job right now, but he is listening in. So thank you very much. I will also introduce or have them introduce themselves. Our legislative aides, Jane Overton. Hi there. And Dan Tadikoff there. And our committee clerk today, she's on loan from the Committee on Transportation, Darlene Semino. Thank you. So just want to tell the general public today we have 3 public hearings, which we will be also listening or hearing presentations by the sponsor and those who wish to testify for or against, followed by 2 bills, work sessions, and that's where the committee makes a decision or continues it. So having said all that, I will begin there to tell you there's been an adjustment to the calendar. We will begin with 1939. We will then go to 1721 and then 1552. Those are the 3 public hearings. We will then do a work session, 1604, and end with 1897. There are also a couple of house cleaning duties we have to do before we end this afternoon. I will begin with The sponsor of the bill, Ms. Semino, is Senator Breen on 1339, but her Representative Moriarty will be presenting. So if he's in the attendees,
I'm looking for, there he is.
okay, thank
Yep.
you.
Coming, hold on. Oh, where'd he go?
Darlene,
Yes.
Darlene, would you also make me co-host? Thank
Yep.
you.
Oh,
Oh.
and the sponsor of the bill is Senator Breen. Nice to see you.
I know, and I lost Representative Moriarty. Hold on just a second.
Good morning, everybody. Thank you for taking us first today. I know you have a big agenda today, and we appreciate you bumping us to the front of the line. Thank you very much. And Representative Moriarty has
Yes.
spent a lot more time studying this issue and the language, applying his excellent legal skills and drafting skills to the issue. So I'm going to let him introduce the bill, and then I'll be testifying in support. Thank you.
Thank you. Good morning, Representative Moriarty. Nice to see you. Oh, you got yourself muted. In this building, you're our next door neighbor in Judiciary.
You as well.
Okay, thank you.
All right. I think I'm here.
Good. Again, this bill is an act to protect school administration officials from harassment and abuse. So would you present the bill, please?
Well, please. Thank you. Senator Deschambault, Representative Warren, and esteemed members of the Committee on Criminal Justice and Public Safety. Good morning, and thank you for the opportunity to speak in support of LD 1939, titled An Act to Protect School Administration Officials from Harassment and Abuse. I am Representative Steve Moriarty of House District 45, which consists of Cumberland and part of Gray. This is my first appearance before you this session. I'm glad to be here. I am a co-sponsor of this proposed legislation, and the sponsor, Senator Breen, has graciously extended to me the opportunity to present this bill before you this morning. I submitted written testimony, but it has been revised when I learned that I would in fact be presenting. Senator Breen and I both represent Cumberland, which is part of an SAD, including North Yarmouth, established back in the mid-1960s. When the pandemic struck 2 years ago, everyone in public service experienced increasing criticism for the state's evolving response to COVID and the medical emergency. But this was especially true for those involved in public education. In schools across the state, school board members, administrators, and teachers often experienced intimidating and outrageous behavior on the part of those who disagreed with the key policy decisions that had to be made to protect public health. The interference with the performing of official duties by extreme and intimidating behavior has made it increasingly difficult for our public servants in education to fulfill the responsibilities they undertook on behalf of our residents and our children. This behavior has also had a significant negative impact on morale, peace of mind, and one's sense of personal security. The behavior is intolerable and unacceptable, and our teachers, school board members, and administrators cannot be expected to endure it any further. As is true of many comprehensive statutes, the main criminal code begins with a section defining key terms. For purposes of the code, the term public servant is currently defined at 17A, section 2, subsection 21, and reads as follows. Public servant means any official officer or employee of any branch of government and any person participating as juror, advisor, consultant, or otherwise in performing a governmental function. A person is considered a public servant upon the person's election, appointment, or other designation as such, although the person may not yet officially occupy that position. The bill, in its amended form, proposes a clarification of the definition to explicitly include school administrators, members of school boards, and teachers, together with others serving in similar positions within the scope of the definition. It adds clarity and helps to eliminate ambiguity. This proposed definitional change is designed specifically to impact section 751 of the Criminal Code, which defines the offense of obstructing government administration. This offense is defined in part as follows. A person is guilty of obstructing government administration if the person intentionally interferes by force, violence, or intimidation, or by any physical act with a public servant performing or purporting to perform an official function. I emphasize that no change at this stage is proposed to the language of section 751 describing the elements of the crime. However, by clarifying the scope of the definition of public servant, those who serve our cities and towns as school administrators, school board members, or teachers will be expressly covered by the protective provisions of section 751. The modification of the definition eliminates ambiguity and uncertainty and expressly extends the protective provisions of section 751 to those who serve our communities in leadership and teaching positions in our schools. I urge you to support LD 1939 as amended, and I'm grateful for your consideration of this amended bill. Thank you.
Thank you, Representative Moriarty. Any questions directed to Representative Moriarty? I see Senator Seaway.
Thank you, Madam Chair, and good morning, Representative Moriarty. Thank you for coming. It's always a pleasure. I used to do DARE classes and went to several schools, and many times I would have an ed tech approach me and saying how they've been abused in their classroom, and the administration would frown on them reporting. And how's this work for them? And it's always been an issue, and I didn't know how this would work for them.
Right. The proposed amended statute includes as follows, the following people within the definition that already exists on the books. So a public servant includes, but is not limited to, a school administrator, a member of a school board as defined in 20A section 1, subsection 28, a teacher, or other persons serving in similar positions. It was my understanding when I agreed to co-sponsor that final phrase, other persons serving in similar positions, was intended to cover people such as volunteer or aides in the classroom, because they almost to the same extent as teachers are in the front lines and bear the brunt of this sort of harassment that's been taking place. So I think, and I certainly intend the bill to be interpreted in such a manner that it applies to aides and assistants in the classroom.
And so this would help enhance that safety net, correct?
Well,
from what I'm
yes,
hearing.
Yes, it would. Now, I will acknowledge, Senator, that Section 751 is perhaps a difficult section from a law enforcement perspective to charge for purposes of charging and enforcement, because, of course, we've got to observe strictly the rights of free speech in all of our undertakings. but at some point that free speech crosses the line into intimidation. And it's designed to provide assurance to the specific public officials I just mentioned that they do have the explicit coverage and protection of 751.
And I guess, what I'm saying is a lot of times in ed techs, they deal with some of the more difficult students.
Yes.
and also difficult parents.
Yes.
And so anyway, what happens is, they're expected to take more in a sense.
Mhm.
And so they want to keep these programs going, so that I think it forces the administration to kind of like be careful of any complaints. And so
Sure.
This is where it puts administration and the ed tech in a tough spot. And so that's what I'm trying to get to. And it's tough.
Mr.
yeah,
Is what Representative Moriarty said sufficient to answer your question?
Yeah, I guess it does. I just didn't know how this would enhance that. That's all. It's just
I
because
think there are others that have questions, and I
Right.
think they might dovetail what you were saying too.
Okay, well, thank you.
Well,
And thank you,
Yeah.
Mr. Moriarty.
And
Of course. Thank you.
I have Representative Pickett, followed by Representative Renicki.
Thank you, Madam Chair. Thank you for being here, Representative Moriarty, this
My
morning.
pleasure.
Having been in the field of law enforcement for 40 years, I know a little bit about the harassment and the abuse, intimidation, and those kind of things that happen. My issue, and I need clarification on is there are statutes in the book in the criminal code right now which deals with exactly what you're talking about, and it allows the courts and the DAs to look at these cases, and it allows them to make the determination if it rises to the occasion of harassment or abuse, as put in the statute here. And I really don't think there is a need to change language to specifically put this group of people in there, because they're already covered. They're already covered in the criminal code. And I'm not a proponent of changing the criminal code and adding things and subtracting things that are already in there and that are working. So I guess what I'm asking is, what do you think about this particular bill, and this proposed amendment to the bill is going to really enhance the ability of a person that does this type of thing being held accountable for it, that is more than what can be done right now?
Thank you, Representative Pickett. I made a short list of other offenses in the code that deal with sort of analogous behavior on the part of offenders, and it includes, and this is not exclusive necessarily, criminal threatening, harassment by telephone, terrorizing, stalking, and disorderly conduct. However, none of those sections specifically reference public servants. By contrast, the existing statute of obstructing government administration does include public servant within its very terms. It's right there in black and white. So the intent was to simply modify or clarify the definition of public servant to make clear that for purposes of obstructing government administration, the teachers, administrators, and school board members were persons who were expressly to be covered by the provisions of that section. They're just not mentioned in the other sections. The other sections that I just read and that you're obviously very familiar with apply to all people generally, without any question. Any one of us is protected by those sections. But given the extraordinary nature of what we've seen in a number of school districts and towns and cities across the state over the past 2 years, it was my feeling when I joined as a co-sponsor that those in public education deserved a little bit more assurance of coverage and protection in our criminal law.
Thank you, sir.
Welcome.
Representative Renecki.
Thank you, Madam Chair. Representative Moradi, I was on my school board for 11 years and always considered a public servant, whether it's actually written anywhere anyway. I have a problem with, I guess, the reasoning for doing this and doing it now. What precipitated this particular bill and the reason for changing it when, you know, it's basically common knowledge that, you know, a school board member is a public servant. So why is it necessary to actually change the criminal code or the code to actually say that when there are plenty of recourse? There's plenty of recourse if something happens. I mean, I wasn't always a popular school board member because I spoke my mind. So, you know, I definitely had parents that had gotten irate with me and other things, but I never considered it, you know, I never considered the fact that it wasn't, you know, something if I felt in any way threatened or harassed, I could obviously call the police. So I don't understand why this is actually necessary.
Well, Representative, like you, I was previously involved in public service, having served over 21 years in my town council. Not continuously, there was a break-in, but still, all told, 21 plus years. And I took my lumps, as I'm sure you did, as a member of the school board. And that's okay, that goes with the territory. But what we have seen, the caliber of what we have seen in the past 2 years certainly far exceeds anything that I personally experienced as an elected public servant, and possibly you as well when you served on the school board. And I would draw your attention to the many items of testimony that have been offered by educators and administrators from across the state, from Fort Kent on south, who have described what they have personally had to endure and put up with and suffer with, given the unique and, I would say, previously unseen types of behavior that the COVID pandemic seems to have prompted. So the goal is to reassure these public servants who have just put up with so much on our behalf that we're aware of their problem and that we want to extend the protection of the law to the greatest extent possible and designate them as those who are specifically to be considered under the obstructing government administration section of the code.
Madam Chair, could I have a follow-up?
Yes, go right ahead.
Do you think that once all the mandates are lifted, this problem goes away?
Good question. I certainly hope so. But you could also argue, and we're both, any one of us will be speculating here, that once behaviors have started and become almost customary, there's a possibility that they can continue. Even in the most mundane and routine things that come before school boards and city councils and town councils and so forth. My concern is that 2 years of highly uncivil behavior in the public arena may endure. And I want to make sure that, I hope it doesn't. I want to do everything I can to make sure it doesn't.
Thank you.
And I
You're welcome.
recognize Representative Pluker.
Thank you, Madam Chair. Thank you for being here, Representative Moriarty.
You're welcome, sir.
I'm just looking at in the index here of where public servant is mentioned in our Federico here. It's mentioned something like 10 times. Is the intent of the bill to also include like teachers around rules around laws around impersonation or those other parts of the statute?
Well, I anticipated the question, and it's a good one. I think the intent was really to focus on obstructing government administration. And I understand that if the definitional section is changed, it applies to every point at which the term public servant appears in the code. And this may be something we can reserve, or you may choose to reserve for work session, but if a preferable alternative is to simply modify section 751 to explicitly include teachers, administrators, and school board members there, then we would eliminate that potential issue. But in those other 10 or so cases, it really wouldn't make much difference. And the intent probably was not to be as broad as that.
Okay, thank you, appreciate it.
Of course.
I have a question, Ms. Moriarty. I'm looking. With this, well, my first question before I forget this one. Was there a bill in the judiciary similar to this defining for election officials? Was it in the judiciary? I seem to recall a bill about harassing, tormenting election officials.
I don't remember. I don't think so. This
VLA.
session.
It was in VLA.
Okay.
Oh, in VLA? Okay,
Yeah, I know of it, but I don't recall it in my committee.
okay. That's interesting that it went to VLA. Why wouldn't it fall under harassment anyways? That the current definition of harassment?
Because I think what we're talking about is behavior that occurs in the course of government administration, as opposed to just neighbors having an argument or argument on the ball field or something of that nature that gets, goes way beyond what is called for. And I think the focus was to as I probably indicated, to look to those people who have chosen a career in public service and education, which carries with it some issues that others don't face in other forms of employment, and to give them the assurance that we know what they're in for, we know what they are putting up with, and we know that they need an extra layer of protection for the duration of this unusual period of antagonistic and threatening type behavior.
And one last question. Would this be just limited to their position in the school, or is this by mere fact they're a public servant and they're home and they're being harassed by telephone or threatened? Does this apply?
Well, I think that intimidation would include, it could be conduct that takes place 24 hours a day. In other words, if you're getting endless phone calls all night long because you are a school board member and because of a vote that you've taken or a position that you've articulated, I consider that to be intimidation of a public servant. So now, if it has nothing to do with somebody's status in the school board, then no, this 751 probably wouldn't apply. But as long as your duties as a public servant trigger this sort of exaggerated and really never before seen response, I want the people to be covered.
Thank you. Representative Pickett and Representative Renecki, you still have your hand up. Do you wish to add anything, or is that an old hand? Okay. All right. And Representative, all right. And thank you very much, Mr. Moriarty. I will now ask those who wish, well, the co-sponsors who wish to testify also. So we'll begin with Senator Breen.
Good morning, Madam Chair. I think given what you just heard from Representative Moriarty, maybe you have a better understanding of why I wanted him to introduce it, because he's much more fluent with the code than I am. And so I'm grateful for you folks for taking us. I'm grateful to Representative Moriarty for stepping into the lead position here. But I'll start with my supportive testimony. Senator DeChambeau, Representative Warren, and members of the Joint Standing Committee on Criminal Justice. My name is Kathy Breen. I represent Maine Senate District 25, which includes the communities of Chebeague Island, Cumberland, Falmouth, Gray, Long Island, Yarmouth, and about half of the city of Westbrook. And I'm here today to speak in support of LD 1939, an act to protect school administration officials from harassment and abuse. All of us who are willing to serve our communities in public service sometimes scratch our heads and wonder why we do it. Certainly, no one goes into public service for the money, at least not in Maine. We serve our communities because we love our work. We recognize the need and we think we have something to offer. Further, we understand that there will be long, tedious meetings, that we need thick skin, and that the job is often thankless. Given these realities, each of us determines to carry on or to move on, depending on our experiences. But what we don't bargain for is the threat of harm to ourselves and or our families, harassment at our homes, jobs, and in our communities, and disruption of our work by our critics. Maine statute affords us, elected and appointed public servants, some protection from the more serious and frightening steps that some members of the public might take against us. My hope in submitting this bill is to extend the protections that we enjoy to members of our school communities and to give law enforcement the tools to protect against threatening behavior. Even before the onset of COVID-19, school board members, superintendents, and teachers were sometimes on the receiving end of extreme reactions by members of the public, whether it came from the left or the right. But aggressive, threatening behavior has increased since the onset of the pandemic. School officials have had to take health and safety precautions that have felt to some families reasonable and comforting, and to other families frustrating and unreasonable. In some communities, including one that I represent, tensions reached the point where school officials felt that their safety was in jeopardy. And you're going to hear from some members of that school community today. We've all seen stories on the news and in social media of behaviors that any of us would interpret as a threat. While we all hope that COVID-19 is waning and that the vitriol facing schools will simmer down as a result, we also know that some unforeseen event or topic can erupt into threatening or violent behavior at any time. My goal in submitting this bill is threefold. First, I'd like to extend to our colleagues in the school community the same protections that we enjoy as appointed and elected public servants. This is where I really like Representative Moriarty's amended language that adds hiring into existing statute, so that no matter how you come into public service, whether you're appointed, elected, or hired, as teachers and other members of the school community are, you would have the same protection from the disruptions in your work. Secondly, I'd like to provide law enforcement with the tools that they need to protect our colleagues in the school community when they experience threats, harassment, or disruption of their work. Perhaps my original bill language or something that Representative Moriarty has offered has something to offer in that respect. And third, I do not want to create a new crime, but rather strengthen the protections that we already have in statute. I don't assert that my bill or Representative Moriarty's amendment perfectly meets the mark, but I hope that you share our concerns and goals in protecting our school communities from danger, no matter the issue that they're tackling. I look to the members of this committee to apply your wisdom and expertise to help achieve these goals, and I'd be happy to take any questions.
Thank you. Representative Wernicke?
I actually got a text message from Representative Newman. He's got a lot of background noise, so he can't ask you a question, but he did ask that if this should, and he makes a good point, if this should go through, shouldn't it include coaches, officials, refs at sporting events, and organizations that oversee school sports and stuff as well?
I can't disagree with that. I think, anybody who's serving in the role of a public servant and the harassment, the threats, whatever, are coming at them because of the role they're playing as a public servant, I think we all deserve the same protections.
Follow up, Madam Chair?
Yes, go right ahead.
Um,
Thank you.
Just as a quick question though, but don't you think we already have those and they already have those protections under the current laws that are there?
Unfortunately, I don't, and that's why I put in this bill. And I just want to circle back also to Senator Searway's question, if I might, Madam Chair. May I address that?
Yes.
Senator Searway, I believe the situation you were talking about is something that would be dealt with in employment law, much more so than in the statutes around criminal law. So if it's a workplace issue where an ed tech feels they're being harassed by a parent or whatever, that's something that they would address under the auspices of employment law. So I just want to clarify that.
Thank you. Seeing no other questions, thank you, Senator Breen.
Thank you so much. I have another commitment at 11, but I'll be listening until then. Thank you all.
Thank you. I saw, oh, there she is. Okay, Rebecca, you moved from this corner to that. There you go again. All right. This is Rebecca, Representative Rebecca Millett, who knows a lot about school issues. So thank you and welcome.
Thank you, Madam Chair. Good morning, Senator DeChambeau, Representative Warren, and esteemed colleagues on the Criminal Justice and Public Safety Committee. I am Representative Rebecca Millett, and I represent House District 30, which includes most of Cape Elizabeth. I am pleased to submit this testimony in support of LD 1939, an act to protect school administrative officials from harassment and abuse. It is no secret that COVID-19 continues to be at the center of debate nationally and locally. I think most of us can agree that we have felt unfortunate divisions grow deeper as perspectives on how to handle the public health crisis diverged. It is my belief, however, that there is still common ground to be found, and I hope this bill is one issue we can agree on. In late summer 2021, growing tensions between parents and school board members emerged as our communities began to consider in-person versus remote instruction, whether there would be mask mandates or only recommendations. In too many cases, these debates turned ugly and in some instances, frightening. Threats, harassments, and assaults towards school boards have been on such a significant rise that U.S. Attorney General Merrick Garland ordered the FBI to work with local leaders to address the disturbing spike. This bill would clarify that the statutory definition of public service and correlated protections under the Maine Criminal Code would extend to principal school board members, superintendents, teachers, and persons serving in similar positions. Those serving in our educational communities deserve to have these explicit protections in place. They teach, care for, and support our children and continuously put their students' health and well-being above their own. They are not paid enough for all they are asked to do, and it is only right that we do what we can to protect them from further harassment and abuse. We must remember at the heart of these debates are our children. All parents want their kids to learn in a safe environment that allows them to explore and thrive, and we want to raise children that are kind and caring towards others. We must also remember that children learn through our actions. And when role models exercise their constitutional right to voice their opinion about public education in their communities in a negative, threatening way, we are setting the wrong example for our children. We must all work together to reduce the animosity recently seen at our local school board meetings and town council meetings. And it is my hope that protections under the law will help to foster a more productive dialogue where we can trust that school board members, city council members, and other school staff have our children's best interests at heart. I will add that we are seeing fewer citizens willing to serve in our local communities. We are seeing significant early retirements of our superintendents, our principals, and our educators. And there are fewer and fewer people entering these fields. We have a significant educational workforce crisis to the point where we enacted emergency teacher and ed tech certification to try to address this issue. And I know many communities are having uncontested school board and town council races. So this is an important step, I believe, that we can take to provide some relief. I thank the committee for your time, and I'm happy to take any questions.
Are there any questions for Representative Millet? I do have, I'm going to ask if you could elaborate, if you are aware of these. I think we've all seen them on the 6 o'clock news. News people like to showcase what's happening in the community, and everything you've described, we've seen that. Are you aware of any arrests or, what has happened after the fact? I'm sure maybe law enforcement was called in. Do you have any idea what has happened currently?
I can't say specifically, Senator. My impression from also observing as, a reader and observe of the media reporting is that I think, and I believe that law enforcement recognizes how difficult the situations are, because these are neighbors, community members, and I think their efforts have been to diffuse the situations, try to bring some calm and some peace to the meetings. I'm not aware of any particular arrest, but I believe there might have been some, oh gosh, now you're asking me to go into your world. Restraining orders.
Okay.
I think there may have been some restraining orders issued, but I'm not aware of any arrests, but that's just me as an observer.
Okay, you're right. I think you're correct, but thank you. Senator Stairway?
Thank you, Madam Chair. And good morning, Representative Millet.
Good morning, Senator.
You still are in my book, so.
Thank you.
Anyway, I just wanted to ask, I know this is just putting public servant in there, kind of making sure it's all covered. Is that my understanding? And so this is not really going to change a whole lot other than making it so that they're protected, correct?
Senator Stairway, I am a big believer in knowing my own limits and boundaries. I would ask that you have had some great testimony earlier from Representative Moriarty. You've got a great analyst and a strong committee who spends hours delving into this. I'm not going to tip my toe into the actual criminal code. We have our education statute book that I know inside and out. Well, mostly, I'm still learning. And I'm sure you guys know yours. So I'm here really just to speak from the education side to say, we have a problem. We had a problem pre-pandemic, and this devolving of civil discourse has made it so much worse. And there is a lot of concern in our committee about how that's going to translate to the educational experiences of our children.
And I hear you, and when I say public servant, I think that, being a law enforcement officer, we hear the same thing. I mean, where everything's weakening the laws, and so when they do, it causes more hardship for being a public servant. And I think that's what you're talking about here too. So I just wanted to make sure that that's what we're trying to accomplish, is trying to strengthen it for public servants and to be able to do the job. So yeah, I appreciate you coming forward.
No, thank you, Senator. And I do appreciate you raising that. And I do trust the committee to have really robust discussions and help us in this situation.
Yeah, thank you.
Thank you.
I will now go to the public. If anyone would like to speak in support of this bill, please raise your hand as the attendee, and we will bring you over and you can testify. I have Holly Blair, Stephen Bailey, and Tyler McGinley. So we'll take three at a time. Ms. Blair, Mr. Bailey, and Mr. McGinley.
I already have Ann Miskowski up first, and then I'll pull the other three in.
Oh, I didn't see her.
I'll pull them in order.
Okay. All right. Miss McCouse, I didn't see the rest of the name, so, so Anne, oh, there it is. I will let you say your last name, Anne, I'm sorry. There you go. Welcome.
Hello, Maximovich. I know seeing it's a little hard to get that. Senator DeChambeau, Representative Warren, and members of the Criminal Justice and Public Safety Committee. My name is Ann Maximovich. I live in the town of Cumberland, and I currently serve on the MS80 51 Board of Directors. I am here today to testify in support of LD 1939, an act to protect school administration officials from harassment and abuse, sponsored by Senator Breen and Representative Moriarty. Our district experienced a very public campaign of harassment, intimidation, and abuse from June 2020 through the election of June 2021. The precipitating event was a statement issued by our district's Equity Leadership Steering Committee, of which I'm a member. This statement was in support of racial justice and condemned anti-Black racism and white supremacy following the murders of Breonna Taylor, Ahmaud Arbery, and George Floyd. A disgruntled parent in the district began speaking out in opposition to the statement and all effort of the district to engage in anti-racism and equity work. He brought in another out-of-state aggressor with a history of harassing elected officials in Falmouth and Scarborough. During this long year, various members of the district, the majority of whom also live in the community, were targeted, including members of the board of directors, our superintendent, and a school social worker. I became a target in September of 2020 when a sign with my photo on it was installed in the yard of the parent, which also happens to be across the street to the entrance to our campus, leading to both our elementary and middle schools. Given the fact the sign didn't violate any state statute or local ordinance, I was left without any recourse but to try and resolve the matter personally. My good faith effort was met with further escalation and harassment. I was issued a criminal trespass warning by the Cumberland Police Department after leaving a note and politely asking for the sign in person to be removed, despite the fact I was never asked to leave or not return to the property. The day after I was issued this warning, the parent installed a larger sign, this one billboard sized, which he self-reported to have set rat traps and electric fencing to protect it from interference. This sign stayed up illuminated at all hours until he took it down in February, only in order to prepare his home for sale. His accomplice went on to create a different sign with my image on it and hateful language, which was placed in various locations around the towns of Cumberland and Falmouth in advance of my re-election bid. One location included the front of my house at the roadside, where he took a photograph and emailed it to me, the board of directors, town council, and chief of police of Cumberland, showing that he knew where I lived and saying that I should be fired. This person told me and the same group in one of his other harassing emails that he would come and steal something from my house. He would destroy it without my knowledge. He would wonder how long it would take for me to figure out what it was and what had happened. I had to drive by these public signs with my photograph as I was taking my two young children to their respective preschool and our elementary school, the library, and everywhere else that was through the center of town. The chief of police repeatedly refused to talk to these individuals since no state statutes or local ordinance were violated. I was told there was a higher standard, a higher threshold for meeting harassment since I was an elected official, but there was nothing that was being done. I was failed by the town of Cumberland, and my fellow victims were failed. If it were not for the involvement of Cumberland County District Attorney Jonathan Sharbuck, I would not have had any personal resolution. No one should experience similar disparate treatment for any reason, let alone for serving the community they live or work in. I ask you to vote to approve 1939 to fill this gap in current state statute. I thank you for ensuring the safety of school board members and school administrators who are serving their communities across the state of Maine, and I'm happy to answer any questions. Thank you.
Thank you. That was threatening to hear. Representative Warren.
Thank you, Madam Chair. Thank you, Ms. Maximich, for being here today. Although I don't have, the only thing I have to say is thank you so much for your public service. And I'm really sorry this happened to you. And I appreciate you being here to share your story. It must have been terrible. And I just want you to know that I felt that very clearly when you read that. And just thanks for sharing a very difficult story.
Thank you. And I mean, I also want to clarify that was just part of it. You know, my address and phone number was put out there with encouraging people to call me in opposition to this equity statement. I got messages from people across the country on my personal Facebook account. You know, I mean, it was a slew of things, but certainly the coming to my house and doing these things, and you know, for there to be this gap in the current state statute, it was really difficult. It did rise to the level of harassment. And once, as I said, once the district attorney was involved, then action was finally taken and a warning was issued. But this could have been prevented so much earlier, where I wouldn't have had to go through this. My family wouldn't have had to go through this.
Thank you.
Ms. I'm sorry, Representative Warren. Okay, you're all set. Thank you.
Thank you.
Anyone else have any questions? Seeing none, thank you very much for coming and sharing.
Thank you.
With that. I now have, wow. I will ask Ms. Semino, were these people ahead of Holly Blair, Benjamin Harris, and Courtney Bololan?
Yeah, the way you see it on the list is one way. The way I see it is the way they signed up.
Yeah.
And I'm going by the sign up list.
Oh, I'm going by the hand list.
I know. Ben Harris and Courtney Bololan.
Yeah, all right. I will recognize, where is he? Ben Harris, welcome.
Thank you, Senator DeChambeau, and thank you for representing Dayton so well.
Oh, the Harris people. Okay. Well-known name in Dayton. Good farmers too. Thank you.
Thank you, Senator DeChambeau, Representative Warren, and the distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Ben Harris, and I'm the proud principal of Bonnie Eagle Middle School, one of Maine's largest middle schools, serving 776 students from 5 towns in southwestern Maine. I also serve as an advanced EMT and deputy fire chief with the Goodwins Mills Fire Department in Lyman. And in my role as a firefighter and EMT, I have received dirty needle sticks while helping opioid users, been bitten in the buttocks by mentally ill patients, and I have watched as our fire chaplain was verbally accosted while working with a family who had just lost their child in a fatal pedestrian crash. In all of these cases, I have moved on from the situation because I was able to accept the fact that these individuals were having the worst day of their life, and it is difficult to handle those emotions. In my role as a school administrator, I have been called names that I didn't even know existed. I have been threatened with physical violence by adults and students for simply trying to explain the actions of their child to them. I have a pretty high stress tolerance, but I can tell you firsthand that in my 10 years as a school administrator, I have watched the civility of our great republic plummet to an all-time low. I now live with a constant stress of potential harm and near daily harassment from parents who believe they can do my job better than me. I have watched as teachers who were once amazing at their craft have become robotic practitioners. I believe this issue goes beyond the COVID-19 pandemic and the real threat to the continued success of our great state. School staff members are public servants, and they should receive the same protection as those who are already afforded the same title. I urge you to all support LD 1939 as written to demonstrate your support to our education community. And I ask you to please vote ought to pass. Thank you and have a great day.
Thank you, Mr. Harris. Any questions of Mr. Harris? Seeing none, thank you for speaking up for your instructors, also your teachers in your school. Thank you. We will continue. I have Courtney Belolan, is it? Okay.
Yes, you are saying it. You're saying it correctly. Thank you.
Thank you. Welcome.
Senator DeChambeau, Representative Warren, and esteemed members of the Criminal Justice and Public Safety Committee. My name is Courtney Belolan. I am the Executive Director of the Maine Curriculum Leaders Association, which is comprised of curriculum administrators, assistant superintendents, principals, instructional coaches, and other instructional leaders in all 16 counties, encompassing over 80% of Maine students. On behalf of our members, I'm testifying in support of LD 1939, an act to protect school administrators from harassment and abuse. As you are hearing and will continue to hear, incidents of harassment and abuse of Maine education professionals has been on the rise. Intimidation and even threats are becoming commonplace for administrators and teachers alike. The growing climate of incivility and conflict around public education is exacerbating the strains already felt by everyone in the Maine education community, from ed techs to teachers to administrators and to school board members. You have already heard examples and stories, and no doubt you will hear more from my ed organization colleagues and other Maine educators. And the Maine Curriculum Leaders Association members have the same stories and similar experiences to share. Expanding the definition of a public servant to include education professionals is an important step in supporting and bolstering Maine educators and the Maine education system, and MCLA supports this legislation. We suggest that the definition explicitly state all educators to make sure that everyone in the education system is included in the protections outlined in Title 17A, Part 2, Chapter 21, Offenses Against Public Order. A related question we have is whether our colleagues at the independent schools with 60% or more publicly tuitioned students are included in this proposed definition, and we believe it is reasonable that they are. MCLA is grateful for this legislation and offers our support of LD 1939 and urges the committee to vote ought to pass. Thank you.
Thank you, Ms. Belolan. Any questions? I think we've asked a lot of questions before you, so
you have.
Thank you. Thank you for coming.
Thank you very much.
And next I have Holly Blair. Welcome, Ms. Blair.
Thank you very much. Can you hear me okay?
Yep, good.
Fantastic. Thank you. Senator DeChambeau, Representative Warren, and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Dr. Holly Blair, and I am the Executive Director for the Maine Principal Association's Professional Division, representing more than 800 pre-K to 12 principals and assistant principals of public and private schools in the state of Maine. The MPA Legislative Committee unanimously supports LD 1939. Across the nation, school administrators and teachers are being publicly threatened, harassed, and abused. There is no doubt that pandemic-induced stress has impacted every single person in our school communities. But right now, school boards, superintendents, principals, teachers, all educators are bearing the brunt of conflicts over masks, quarantines, vaccines, and other highly charged issues. Please know that this is a national epidemic, and this has got to stop. From navigating protests over other displays of defiance to being assailed on social media and targeted with attempted arrests, using zip ties, school leaders face escalating threats and violence simply for doing their jobs. This is urgent and educators need help. And I strongly encourage for those of you, I know that there were a lot of written and testimonies, but unfortunately they weren't able to join us live today simply because it's in the morning of the last day before February break and they're all in their schools teaching and leading the students of our state. By adding all educators to the definition of public servant, this will take the next step to protect Maine educators from potential harm and harassment and allow them to do their job of educating Maine students to the best of their ability without the fear of abuse. For these reasons and many more, the MPA strongly encourages the committee to vote unanimously ought to pass on LD 1939. Be happy to answer any questions.
Thank you. Any questions of Ms. Blair? Seeing none, and thank you for coming. Thank you.
Thank you.
I now have John Kaczynski.
Hello, good morning.
Good morning.
Senator DeChambeau, Representative Warren, and other members of the Criminal Justice and Public Safety Committee. My name is John Kaczynski. I'm here on behalf of the Maine Education Association to testify in support of LD 1939. The MEA represents 24,000 educators in our Maine system of public education, including educators in nearly every public school in the state. Over the past 2 years around the state and around the country, school board members, teachers, administrators, and other educators have experienced a new level of vitriol and anger directed at them from disgruntled parents and citizen activists. The pandemic and the struggle of providing a public education during the pandemic have created deep divisions in some communities. Mask mandates have taken a lot of the attention, but like other places around the country, some parents and other activists are now raising issues about the programs and curricula in schools and using social media to spread confusion, biased views, and to organize opposition to practices that are inclusive for all students. Teachers, administrators, and educators are bearing the brunt of this anger. Just this week, a certain podcast blasted specific teachers by name, castigating one for being the staff liaison to a gay-straight alliance club in a Maine school. Maine's Teacher of the Year was subjected to a social media tirade and organizing effort to raise concerns about book choices available to students. When schools were regularly engaged in remote learning, repeatedly lessons were recorded, distributed on social media accounts with facts twisted and words misconstrued, and the teachers were subject to messages filled with misplaced anger and vitriol. And we wonder why we have such teacher shortages across the state and across the country. Along with these attacks on educators, we have seen an increase in animus towards teachers' unions in some communities, as teachers' unions are often blamed. Leaders of our union have argued for mask mandates because they believe it will help keep kids and educators safe during this unbelievable moment in our history, and because they believe it will help keep schools operational for in-person learning. In-person learning is the chief concern of many educators around the state. Yet offering this position in a public school board meeting has resulted in teachers being doxxed, physically accosted and yelled at, called child abusers by angry parents. This isn't hypothesis. This has happened to teacher union leaders, actual teachers from local communities at school board meetings in our own state. Let's be clear. Passing this bill will not solve the problems teachers, administrators, and others face in this new environment. As hard as you may try, you can't legislate to require people to behave better. You can't create laws to require parents and community members to treat educators and public servants with the basic decency all humans can and should expect. But passing LD 1939 can provide educators and law enforcement with one more tool to counter the most egregious examples we are seeing. It will provide one mechanism to address the most disruptive and intimidating behavior. Passing LD 1939 will articulate for educators, school board members, and the public the important and valuable role of all partners in our public education system, and that the legislature has our backs. As others, like Ms. Blair and Ms. Bailolin, we would echo the potential for an amendment here. The current version of Representative Moriarty's amendment reads, teacher or other persons serving in similar positions. We think all school employees should have the protections afforded under LD 1939, and school employees is all encompassing and covers everyone employed by a school, including teachers, ed techs, bus drivers, coaches, and others. We worry the current language, specifically the language persons serving in similar positions, is vague, would likely lead to litigation in order to interpret what employees the phrase refers to. So instead of teacher or other person serving in similar positions, we suggest teachers or other school employees. Thank you for your time and for your service to the people of Maine, and I'll do my best to answer any questions you may have.
Thank you very much. Mr. Kaczynski, you said you were with MEA?
Correct.
Okay, thank you. Any questions? Seeing none, thank you for your testimony. And I will go to Stephen Bailey, followed by Tyler McGinley. So we'll have Mr. Bailey.
Good morning. I'm glad to be here this morning. Senator Deschambault, Representative Warren, and members of the Committee on Criminal Justice and Public Safety. I am Stephen Bailey, Executive Director of the Maine School Management Association. I'm here today testifying on behalf of the legislative committees of the Maine School Boards Association and the Maine School Superintendents Association in strong support of LD 1939 as amended. Elected school boards and the superintendents they employ to run our schools understand they're in the public eye and anticipate the decisions they make can be controversial. This is part of their job. They understand that. That has been an understatement during the COVID pandemic, when to keep students safe, the people we represent had to close schools, limit the length of school days, and put restrictions on class sizes and gatherings. What we did not expect, on top of dealing with COVID, was a backlash based on misleading accusations about what we were teaching in schools around race relations as part of our history as a country, teaching that history is not only essential to a well-rounded curriculum that gives students perspective, it also is law. 20A subsection 4706 requires instruction in American history, African American studies, Maine Native American history, and the history of genocide. A few examples will demonstrate the severity of that backlash, and you've heard some of them already today. These have been fueled in part by the national organization No Left Turn in Education, using the outdated term critical race theory, which has become incendiary. Individual teachers and administrators have been singled out for huge criticism. In 2021, there was a petition to recall school board members in MSAD 51 serving North Yarmouth and Cumberland over the hybrid learning plan adopted due to the pandemic. In Hamden, there was an effort to make what was taught in history class about slavery an issue in the school board election. In Gardner, the school board came under attack for its suggested reading list for a college-level elective course. We've also attached to this testimony a story from the Ellsworth American dated January 14th, 2022, where a member of the public at a board meeting threatened a lawsuit and potential harassment of the board over the district's masking policy. In that story, the resident was quoted as saying during public comment, and I quote, "You guys have 90 days to comply or else we start getting dirty. We're not the type to commit bodily harm, but we can make damn sure that you can't walk anywhere in Ellsworth without ridicule." School boards and superintendents can handle discussion and lively debates around controversial topics. What we can't abide are actions that seek to intimidate or threaten school officials. We have heard of confrontations in grocery stores, board members being followed out to their car or followed home. And in one publicized case you've heard of today, harassment, intimidation, and threatening in Cumberland, a life-size poster of a school board member surrounded by rat traps and illuminated at night was put up across from Greeley Middle School. This bill expands the definition of public servants to include superintendents, board members, and we assume other school leaders like principals, teachers, or other persons in similar positions. And we support the amendment to include all school employees so that there will be consequences if harassment or abuse or threatening or intimidation or disruption of public meetings occurs. Finally, we have included the definition of harassment in statute 17A while escalating consequences for repeat infractions. Now, we agree that section 751 also should be the focus of this bill, but we also wanted to make sure harassment was mentioned here. A person is guilty of harassment if, without reasonable cause, the person engages in any course of conduct with the intent to harass, torment, or threaten another person after having been notified in writing or otherwise not to engage in such conduct by any sheriff, deputy sheriff, constable, police officer, or justice of the peace. The notification not to engage in such conduct expires 1 year from the date of issuance, or a court in a protective order issued under Title V or Title 19A. We believe this bill will give us additional avenues to try and protect school leaders by making it clear that harassment is against the law. And this is even more profound than my testimony even can be provided this morning. We could have provided numerous other situations where this type of mob behavior has been extremely threatening, intimidating to the productive and respectful and civil administration of our schools and school units. So we would highly recommend that you support this and vote ought to pass. Thank you very much, and I'd be very willing to take questions.
Thank you, Mr. Bailey. Any questions of Mr. Bailey? Seeing none, thank you for coming and giving your testimony today.
Thank you.
I will now recognize Tyler McGinley.
Thank you. Senator, I have to say your name the right way, so I say it the right way.
Go ahead. DeChambeau.
DeChambeau, thank you. Representative Warren and members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Tyler McGinley, and I am here as a representative of the MSAD 51 Board of Directors from Cumberland and North Yarmouth. I'm here to testify in support of LD 1939, an act to protect school administration officials from harassment and abuse, and I'm grateful for the opportunity to speak with you today. In addition to being a woman, I am a wife. I'm a mother of 2 school-aged children and a school board member since 2017. I stepped into the role of chair in June of 2020. I grew up here in Cumberland, and I'm beyond grateful to have the opportunity to serve my district in the way that I do now. Just as I began my chair role in June of 2020, so did an organized effort to intimidate, harass, and ultimately threaten me by a disgruntled parent in our district. You have already heard from a member of the board from our town as well, Ann Maximovich, from similar situations that happened over the past 2 years. This began by recording my phone conversations with this parent when I was trying to understand his concerns, where he took those things, played them back out of context at public board meetings to intimidate, harass at any opportunity that he had. I do want to mention that our board also includes 2 student members that sit on stage with me every single time that this harassment and intimidation happened. He did not ask me if it was okay that he recorded me and continued to play these messages. It was extremely challenging for me to conduct my meetings in public in a professional manner, to do my job as chair, and all while trying to keep our district above water during a global pandemic. The fear and anxiety that I brought with me to every part of my role as chair was debilitating, and it lasted for over a year. It rippled into my personal life, my 2 children. It affected my husband, and as you have heard, other members of our community. This example of a phone conversation is one example. I was harassed on a daily basis for over a year. Only after I was able to get the Cumberland County DA involved was I actually validated and listened to. I asked for help from our police department on a weekly basis and was told that, like you have heard many times today, that he's a good guy, you're a public official, it's okay, buck up. Due to the lack of support and protection, this parent was continued to feel emboldened and did not stop his actions. In the spring of 2021, he chose to threaten me. He chose to threaten to release another recording of a supposed conversation between him and my father unless I resigned. My father had passed away just a few months before this threat, and this parent knew this. Now the death of my father was being dangled as a new tool for harassment and threats with no recourse. If there is an assumption that this is already covered under the existing law, it is incorrect. And it is in a gray area that needs to be corrected. We need specific protection. I have committed myself to making sure that this does not happen to others in the future. I have engaged in restorative justice efforts with this parent to see if there is an effort of clarity, yet there has been no signs of remorse, and he continues to do it at other districts throughout our state. Finally, he was served with an improper influence of an elected official because of the threat that I received in spring, but that is the only thing that has happened. I can't help but think that if this change was in place last year, how much trauma our community could have avoided. I want to agree with some of the things that have been said. This is not just specific to COVID. This is something that is about all sorts of different topics. And I would love to think that when the pandemic is over, that this would go away. However, I feel like too many people have been emboldened by a lack of protection to our school employees and public officials that it will not go away. I urge the committee here to vote to pass. Thank you so much, and I'm happy to answer questions.
Thank you, Ms. McGill. Any questions? Seeing that had a lot of publicity attached to it, Ms. McGinley, whatever happened, is it still happening? Is something stopped? I heard you say there was like a caution or.
So there was, once the threat, once he was served with, from our police department, he admitted that he was going to do this in the police report. The DA served him with improper influence of an elected official. He was given a, sorry, I'm not having the words. He was given a, I can't think of it, something that will hold off of his charge if he completes community service and restorative justice with me. He completed that a couple of weeks ago with my family, and it was a horrible experience. So there has been, that has been the only thing responded to. I was on the cover of the Boston Globe with my children for this. I gave you something this small. This was the example of a year and a half's worth of harassment and threats.
Thank you for sharing that with us. It's important to know that. Representative Warren.
Ms. McGinley, thank you for being here. And I want to say also, I'm so sorry this happened to you. Thank you for your public service. And I hope that we can try to make a difference for folks.
Thank you. And thank you so much. The only other thing I will say is that this bill being passed, or this change being passed, is going to help us continue to encourage people to run for office. We have a really hard time getting people to sign up to even come to informational sessions to hear about what it means to be a school board member. No one in these communities want to sign up for those roles right now, and this would help us change that.
I hear that, and I bet that also some people resign because of harassment, right?
We had one member resign due to his personal choices. And we've had members not want to run again. We've had people leave committees. I mean, yes.
Thank you.
Thank you. Okay. And that seems to conclude those who wish to speak in support. If I'm missing anybody, I have Jeff Porter. I believe he's from that area also. Jeffrey Porter, you wish to speak in support?
He's coming right now.
Thank you.
Yes, thank you, Senator. I'm sorry. Can you hear me now?
Yes, go right ahead, Mr. Porter.
All right, thank you, Senator DeChambeau, Representative Warren, and members of the Joint Standing Committee on Public Safety. I'm pleased to be here and present some testimony. My name is Jeff Porter. I'm a lifelong Mainer, and I've been a public school educator for 28 years. I've served as a superintendent of schools in Cumberland, North Yarmouth for the last 8 years, and I was assistant superintendent in Bedford for about 8 years prior to that. I'm grateful to Senator Breen for sponsoring this bill and Representative Moriarty for co-sponsoring this bill. And I'm in full support of LD 1939 in its objective to clarify the definition of public servant to include teachers, principals, superintendents, and school board members. And while I would prefer that this was a more inclusive of all of our school staff, and hopefully the language that Representative Moriarty talked about can achieve that. In its absence, I still urge passage of this bill as an important next step. Being a school superintendent has never been easy, and that's to be expected when you sign up for it. But what happened between June 2020 and July of 2021 goes far beyond the expectations of this job. You've heard some things earlier today. I'd like to talk a little bit more about my specific experience. So as you heard, a parent in our district initially decided he didn't approve of the work we were doing around race equity in our schools. He was determined to stop that work. This later transferred into our response around the pandemic and then just about every other matter you can consider that faces schools. There's a lot of things I could tell you about this experience. As Tyler mentioned, she gave you just one small nugget. But yeah, I could tell you how we tried to coerce me on 2 occasions into abandoning the equity work early on by threatening to create problems for me if I didn't comply with his demands. Things like, you have roughly 5 hours to make the right choice. How he repeatedly demanded my resignation, termination on social media, dozens of school board meetings, on signs plastered all over the community, and in emails. How he left flyers on student desks at the high school, criticizing and demeaning me. How he posted over 200 social media messages defaming me, labeling me, such as a Marxist, communist, socialist, anarchist, among others. How he FOIA'd the district 55 times in less than 1 year and said he was doing this so he could bury us in paperwork. How he placed a billboard with my photo on it in the center of Cumberland and neighboring Falmouth with lies and distortions and posted all of it on social media afterwards. How he posted my voter registration card online, read my address out loud, posted my address on social media, included my home address and party affiliation. How he walked by my seat at a board meeting one night and physically hovered over me in an attempt to intimidate me. How he created a spoof account on Twitter called Jeff Porter's Conscience and filled it with taunts and lies. Twitter later removed it for violating their code of conduct. How he taunted me through numerous emails with things like students have hurt themselves and are thinking of killing themselves at record rates because of your decisions. Blood will be on your hands. I hear there's a pack of lions on your trail, so you might want to try and run out of town or just get into a fetal position. That's one example. How he placed dozens of fire porter signs around the community, with many lining the front yard of the primary school, several yards from a row of classrooms. Several others were placed several feet from my office window, and there they stood for the next 3 months and became a preoccupation and had a negative cultural impact on our school community. How he taunted me about the signs in an email and said, as you either leave work tonight or come in tomorrow, you will see a handful of signs in the state of Maine and Cumberland town right-of-ways. Removal of these signs is a Class D crime with offenses carrying a penalty of up to 364 days in jail. It would be tough watching your daughter's swim meets or checking out colleges with your daughter, allegedly, when you're in prison. How he went on a national syndicate show like Tucker Carlson and Laura Ingraham, using his connections as the state chapter president of No Left Turn in Education by falsely accusing me of restricting him from attending his own daughter's graduation. He had wanted to gain national attention for over a year and he got it. How he solicited hate calls and emails to be sent to me from across the country after his appearance on the Tucker Carlson show. And how he encouraged and joked with people from across the country on social media with his newfound notoriety. Some of the posts said things like this: this man should have a mob behind him with pitchforks at the ready The superintendent needs a smackdown. I'd catch this piece of shit out when he's alone, and I'd curb stomp this POS. I would go to the graduation and I'd make sure that you especially beat the motherfucker's ass beforehand. Excuse the language, it's not mine. Have you ever seen how violent a moose can get? They can be deadly violent. Don't try to pet one. This guy needs to be stripped naked, sprayed with moose scent, dropped into one of Maine's forests. And Sean McBriarty's response, I know a guy. I suppose I could just dismiss most of what I've said so far as the antics of a determined bully and just someone using his First Amendment rights. He used the same tactics that a couple of 8th graders when I was in 7th grade used when they want to be a bully. But that's not the end of it. On at least 3 occasions that I'm aware of, he visited my house, which is located in a different community 25 minutes away. He had no reason to be there. On one occasion, he waited in his truck at the end of my driveway as my wife and I were leaving the house. 2 days later, he was filming my son playing basketball outside of our house in the evening. He then reported at the next school board meeting that he had verified my home address, and then he read it out loud. He had a friend in him come to my house a 3rd time months later when we weren't home and placed one of his fire porter signs on my front lawn, took a photo, and then shared it on social media as a joke. After his appearance on the Tucker Carlson show, he announced my home address and posted it on social media, advocating for people across the country to come to my house. I stayed home from work for at least 1 day during that week because my teenage children were in remote school that week, and I didn't want them to be alone. I was told by 2 different police agencies, attorneys in the DA's office, that because I was considered a public figure and I was known in my community because of my name recognition, that I had little protection under the law. I did not meet the definition of a public servant under the statute. In other words, because of my occupation, the rights afforded by law to others do not apply to me or any of my colleagues, any school administrators, teachers, or school board members. Please amend this law. What I and others in our school community endured for over a year should not be part of anyone's job description. Please make this change, and I thank you for your service and for listening today.
Thank you, Mr. Porter. Any questions of Mr. Porter? You have vividly expressed for us to see the fear in that, and especially for your family. So
Thank you, Senator.
thank you for coming. So that seems to conclude all those in support. I will now ask for those in our attendees list who wish to speak in opposition of this bill. Please raise your hand. We'll let you in. I don't see any. Anyone wishing to speak neither for nor against this bill? Please raise your hand. I don't see any either. Therefore, I will close this public hearing. Mr. Porter and everybody else who's still here, I don't have my weekly list here. We normally have a work session where we will discuss it among ourselves publicly, and there will be a vote. And it's usually about a week later. If Ms. Warren has it.
It's next week on the 25th. We have it listed for a work session at 1 p.m.
Or thereabouts.
Or thereabouts. And thank you, Mr. Porter, for being here and sharing your story. And I'm really sorry for everything that's happened to you and your family.
Thank you.
Thank you all for coming. All right, so we will move on to our other bill. And it's public hearing 1721. Representative Rachel Talbot Ross, an act regarding dignity for women in correctional facilities. Is
She's coming. She just got on.
Okay, good. Thank you.
There she is. She's arrived.
Oh, welcome, Representative Talbot Ross. We have your bill before us, and I believe you know everyone here, so you may proceed.
Thank you so much. It's good to see you all again. Senator DeChambeau, Representative Warren, and the esteemed members of the Criminal Justice and Public Safety Committee. I am Rachel Talbot Ross. I represent House District 40, which is part of Portland. Thank you for the opportunity to present LD 1721, an act regarding dignity for women in correctional facilities. Members of this committee who served during the 129th legislature may remember this bill as LD 1422. Sadly, little has changed since we first presented that bill in March of 2020, shortly before our early adjournment due to the onset of the COVID-19 pandemic. The number of women who are incarcerated in Maine jails and prisons has risen dramatically, as you all know, in recent years. Between just 2012 and 2018, new prison sentences for women increased by 65%, while prison admissions for probation violations for women more than doubled. We know this trend continues today. As the Council of State Governments noted in its research on justice reinvestment, Maine's correctional system has experienced significant challenges due to this rapid increase. Our jails and prisons were designed with men in mind, and the truth is that we are not adequately providing for Maine's incarcerated women, and by extension, their families and communities. I want to speak specifically to incarcerated parents for a moment. Nationally, 58% of incarcerated women and 80% of women in jails are mothers. Parents don't stop being parents when they're incarcerated, and gender responsive policies will set both parents and their children up for more successful futures. It's critical that our correctional system supports families and that visitation policies and facilities are not only responsive to children's needs, but further provide the time and space for the parent-child relationship to develop and flourish. After years of watching the rate of women who are incarcerated increase, it is time that we adequately respond to their unique needs. Providing gender-responsive services will better protect the rights of incarcerated women, honor their health and safety, and improve their individual chances of success. Beyond that, it will strengthen their families and communities, allowing for successful reintegration and decreasing recidivism. Ultimately, that saves taxpayers' dollars. It decreases our prison population and lessens the strain that the system is currently under. Simply put, and I believe that you believe this as well, that you know this, that this is simply good public safety policy. LD 1729 seeks to create the mechanisms necessary for a more efficient, gender-responsive system. I will say that I know we've taken a number of steps over the years to be mindful of this, and I want to thank this committee for its support. The Office of Child and Family Services has reached out to me and has raised some good points. And they've indicated that in the bill that the data gathering and reporting component may need to be amended. I agree with them. We need to take a closer look at the portions of this bill and clarify that data reporting element. I know that they are willing to work with me on this before the work session. So with your permission, I would like to work with stakeholders to come back at the work session with an amendment that addresses OCFS's concerns. I would also like to work to update section 10 in the amendment in the bill to encourage facilities to make every effort to provide gender responsive transportation. I really did hear the sheriffs the last time we visited this issue and understand the challenges to adhere to this because of our workforce challenges. It is not meant to be a mandate that we cannot maintain or fulfill. And so I would like to work with them again before I come back to the work session to kind of revisit that provision and really try to put language in that encourages as much as possible a gender appropriate transport when available. In 2020, the Department of Corrections testified in agreement with the idea established in this bill that creates a Board of Visitors for Women's Services alone, a separate Board of Visitors for the Women's Services. They testified in favor of that. I want to acknowledge and sincerely thank the Department of Corrections for its position. And while I have taken their suggestion to limit the number of members to that new BOV to 5, in order to be consistent with the commitment that we've made to gender responsive services, I still believe those boards should increase those numbers to 7. I believe that we should allow at least one member with knowledge of issues related to the incarceration of women, as well as one member who represents the lived experience of formerly incarcerated women who have been involved with OCFS on those Board of Visitors. Furthermore, I am committed to specifically including the 4 membership categories listed in this bill that would be required for the newly created Board of Visitors for Women's Services. You see it in the bill, but I'll just reiterate, on the new Board of Visitors for Women's Services, I believe that we should have at least 4 members that fit these following categories. 1 member who was formerly incarcerated, a former resident. 1 member who represents a sexual and reproductive healthcare and education provider. 1 member who is a healthcare practitioner who provides sexual and reproductive healthcare and education to women, and 1 member with an understanding or experience with domestic violence. I remain dedicated to moving this measure forward to protect the dignity of women in our correctional facilities, and I deeply appreciate your attention to these issues. I can answer any questions, help clarify pieces of the bill. Again, thank you for your work on this issue and your attention to this bill.
Thank you. I have Representative Galgay Reckitt, who has a question.
Representative Talbot Ross, as I think you know, I, in my other life, ran a program that established the first entry into the women's prison system of a program to work with women who'd been victims of domestic violence. And starting in the county jails, which is the other piece of this in my head, we had done a survey of 100 and I just raced in from the dentist. It's out of my brain to get back in gear. We surveyed or worked with 100 women in the Cumberland County Jail, only to discover that something like 97% of them had been victims of violence. And from that time, and I couldn't tell you the year now because I've been gone for a while, but probably 10 years ago, we started doing that. And we worked in the MC, the Maine Correctional Center, as well as the jail for all those years. And I believe that program is still going. So my concern is that my question is, have you talked to any of the staff who have worked in that role? I don't know who does it beyond what used to be Family Crisis Services and now through these doors, but I believe they still have a staff person who does that work in the jails. So I'm asking if you've had any interaction with them in designing this.
Yeah, thank you so very much for the question, Representative. And I want to just honor the work that you have done and did do for decades. Many times you were the only one there for so many of our justice-involved women. So I want to thank you for that. I've not spoken specifically to those staff members or those nonprofit organizations that are involved in this work, but I have been working with women at both the Southern Maine Women's Reentry Center and women at the Women's Center in Wyndham, current residents of those facilities, in looking at this bill. And I believe that Wendy Smith, who's with us, and has been working on this bill, will testify shortly after I do. But this is really informed by work that we started several years ago with Planned Parenthood of Northern New England, and actually women who have been raising this issue around their sexual and reproductive health concerns within these facilities, but also really raising the issues around the parent-child relationship and how they can maintain their duties as a primary caretaker. They've raised the flag around family reunifications. And so not working with those folks specifically in our jails, but absolutely wanting to connect with them and very much open to addressing some additional issues that may be present due to incarceration throughout our jail system. So I thank you very, very much for that question. And again, for all of your work.
Thank you.
I've got obviously some concerns, some questions, and I do support the purpose of this bill and your intent. But I guess Representative Reckett and I probably should write a book after I hear that. Some of these things have been attempted in the past, such as especially contact with children. I'm sure in your deliberations of this that the primary caretaker of children isn't necessarily the mother or the female. And there is one facility that is co-ed, the Maine Correctional Center, as you well know. And one attempt was made, a first attempt, that to engage the mom and the child. And then the men came forward and they were pretty well screened that they were the primary caretakers of their children prior to incarceration. Do you foresee, I'm looking at the summary, it says, everywhere else it talks about women, but there's a part, the bill adds to the rights of a person who is incarcerated. So could you, I'm leery of something, there's a lot of good in this bill, but in that particular environment, I'm thinking of the males also. Did you give that some thought, especially contact with children and programs to deal with children?
Well, I thank you, Senator, for calling your attention to that. I'm really appreciative of it because it gives us the chance to focus on what's really at the heart of this, which is the children. And for us to make sure that the parent-child relationship, whether that primary caretaker is a male or a female, has any gender identity, that is respected. The heart of this is to respect that relationship between a parent and a child. Because as I said in my testimony, becoming a resident of one of these facilities takes an enormous toll on our children. And that is a generational effect. It has impact beyond what we can articulate in this moment. But if you look at all of the social determinants of health, you'll see that one aspect of it is this type of trauma that can be attributed to a lack of this maintaining a solid family parent-child relation. So at the heart of this bill is our protecting those relationships. And it says persons in order to allow for a parent, however they identify, but certainly male and female parents to be able to maintain those relationships with their children. I hope I've answered that succinctly. We want the parent-child relationship to be maintained in all of the ways that OCFS and the Department of Corrections helps to keep those relationships healthy and whole.
Thank you for that response. I do want to take a moment with Representative Reckett talking about the programs and especially domestic violence. You meet a need. I'm going to take one moment to tell you about a very successful program. It's called HIP, Helping Incarcerated Parents. Both males and females of the co-ed facility were engaged. It prepared them before they could see their children, not before, but to have a not sitting across from a parent relationship, but actually getting on the floor and playing games and what have you. So there was an education component and then a weekend where the caretaker in the community, and that's probably Grammy, bringing the child and that building a family. So I'd be glad to discuss that with you. I think you're going towards that. It's not just getting a visit. It has to be a whole different kind of visit. So
Thank you for that. Thank you, Senator. Thank you. The focus has to be maintained on protecting those relationships to the degree possible.
I will tell you that program was developed by a teacher in the correctional facility. And in those days, people in the community, educators, did not appreciate. Now there are more people wanting to come in and share the education piece of childhood development. Thank you. And thank you all for listening to that. Very successful. Any questions for Ms. Ross, Talbot Ross? Thank you. So I will move on. Anyone else, any legislators here who wish to speak on this bill? I don't see any, so I will go with, I've got Wendy Allen Smith. Wendy, are you speaking in favor?
Yes.
Go
Yes,
right
I am.
ahead. Thank you.
All right. Thank you, Senator DeChambeau, Representative Warren, and the members of the Criminal Justice and Public Safety Committee. My name is Wendy Allen Smith, and I'm from Milford, Maine. I am a formerly incarcerated woman in long-term recovery. Today, I am the Young Adult Diversion Program and Policy and Advocacy Lead for the Restorative Justice Institute of Maine, a coordinator for the Maine Prisoner Advocacy Coalition, and an organizer for Maine Recovery Advocacy Project. I'm here today to testify in full support of LD 1721, an act regarding dignity for women in correctional facilities, the amended version that Representative Talbot Ross just previously spoke about. I'm a mother to 4 amazing children, Whitney, Damian, Kelsey, and Callie. During my 4-year incarceration, I didn't have an opportunity to see my children at all. I was told that there was a notarized paper that was needed, although I didn't have DHS involved at any time. I voluntarily signed my children to my mother while I was working to get my life on track. My prior prison sentence, I didn't have to have this paper, so it left me confused. When I asked about the reasoning, I got multiple different answers. One was it was required through DHHS, and the other was it was required through DOC. I still don't know which one's accurate. The effects on mothers that are inside and unable to reunify with their children is substantial. I've seen women have to sign custody over and have their children adopted out due to their length of sentence. How's that helpful to the mother that's trying to rehabilitate or the child? I've seen mothers regress, lose hope, and give up on their journey of rehabilitation and recovery. Let's talk about the affected children. My children suffered greatly from the lack of ability to interact with me while inside, not being able to see me and know that I was okay. Kelsey, at the age of 12, developed an eating disorder that she is slowly recovering from. She's now 14. I would just like to take a minute to read a poem that she wrote showing the effects of what incarceration and lack of ability to connect causes. It's called Through the Lens of a Child. The year of Disney movies and tag, we guzzled down apple juice and played hide and seek. By the time we turned 6, we learned how to cook our own food and how to take care of ourselves. Once I hit 7, I moved in with my grandparents. Mom was taken. Where did she go? Will the bad guys bring her home again? Mama, come home. I miss you. At the start of age 8, I never understood why I felt so alone. At such a young age, I still laughed with my friends and made sure my Barbie dolls were okay. But why didn't anyone check in on me? Fast forward to 13. The only way I could cope with my feelings was through starving myself. If I could focus on the amount of calories I consumed, I wouldn't have time to think about my mom being stolen from me. Now, age 14, Mama is home. Mama is healthy, but the time is gone. All the years that could have been spent at Sweet Frog or coffee dates with her are gone. My childhood was stolen. My mother was ripped away from me. That is what incarceration does to a child. It rips their one tiny spark of hope away from them. The light at the end of the tunnel, burnt out. But us kids will still act okay because no one wants to sit down and ask if we're really fine. Thank you.
Thank you, Wendy. Any questions for Wendy Smith? Seeing none, thanks again. And now I have Michael Cabetta. Welcome, Michael.
Thank you, Senator DeChambeau, Representative Warren, and distinguished members of the committee. Good morning. My name is Michael Cabetta, and I'm Policy Counsel for the ACLU of Maine, a statewide organization committed to advancing and preserving civil rights and civil liberties guaranteed by our state and federal constitutions. On behalf of our members, we urge you to support this bill because it would ensure that women incarcerated in Maine are treated with greater humanity. You've heard what this bill does, so I won't dwell on that. Suffice it for now to say that although Maine's prisons and jails are overwhelmingly filled with men, the number of women Maine sends to jail and prison has climbed astronomically over the past 50 years. According to the Vera Institute, the number of women in Maine's jails has increased more than 64-fold in the last 50 years, from 4 in 1970 to 258 in 2015. The number of women in Maine's prisons has increased more than 15-fold in the last 40 years, from just 10 in 1978 to 152 in 2017. The ACLU supports each provision of this bill, even though it would not tackle the staggering increase in the number of women Maine incarcerates. What this bill would do is ensure that the women in the custody of the Maine Department of Corrections and their family members are treated with greater dignity. Although we support this bill as written, we wish to point out an opportunity to improve the bill, namely the section of the bill that would ban Maine's correctional facilities from billing indigent people in correctional custody for future payment of services and medications should be extended to all incarcerated persons, regardless of income or indigency. This change would make it easier to apply this section in practice by removing the need to determine indigency each time a correctional facility wants to charge an incarcerated person. It would also ensure that the state, the appropriate institution, pays for the medical costs of those in its custody. We urge you to vote ought to pass. And I thank you as always for your time and attention, and I'm happy to try to answer questions.
Very good, thank you. Any questions for Mr. Cabetta? Seeing none, thank you. I am looking. Sheriff Trafton, are you here to testify in support of this bill?
No, ma'am.
Okay, let me just finish with the group.
Madam Chair.
Yes.
Representative Galgay Reckett has a question of
Okay.
Mr. Cabetta.
Thank you. I didn't
You're
see
welcome.
that hand.
Sorry, it didn't go up fast, so it's not your fault.
No, let's get him. Mr. Cabetta, oh, there you are. Okay, Representative Reckitt's got a question for you.
Yes, sorry, I didn't get my hand up fast enough for you to see it, so it's not your fault. Anyway, I'm interested in what you're saying, Mr. Cabetta, but I don't see it in the text of the bill. Have you provided a suggested way to amend it, or what am I missing here? Which section talks about the things that you just mentioned in terms of medication and indigency?
Yeah, just give me a second and I'll tell you the line.
Oh, I see it now. It's down in
Okay.
section 8.
Yes,
Okay. Do you have a suggested rewording that you could provide to the committee for the work session?
I do. And just as a preview, I think it'll be a very simple removal of the word indigent or indigency.
Okay. All right, thank you very much.
My pleasure. Thank you, Representative.
Okay, thank you. I am, is it Dusty Sprague? If you're in support, Jan Collins, if they would come in, I will recognize them. Representative Rickett, you want to put your hand down?
Oh, yes, I do.
Slowly getting up, slowly getting down.
But my teeth are good now.
Okay. All right, so I called in, yes, Dusty Holman Sprague, welcome.
Hello, good morning, folks. I'm Dusty Holman Sprague with the Maine Women's Lobby. Thank you, Senator DeChambeau, Representative Warren, and members of the committee. I have spent much time before you over many years, but not this session yet, so I'm happy to be here with you today. As I said, I'm here on behalf of the Women's Lobby, which supports gender responsive and gender equitable public policy with a focus on those most harmed by misogyny and sexism. And so that means this bill is really important to us. We are here in strong support of 1721 and thank Representative Talbot Ross for her work on this. We were really happy to be partners on the early iterations of this bill and the bills that she referenced that led to this creation. And early conversations with both directly affected folks and also the department and OCFS. So the core things that we really particularly appreciate and want to lift up about this bill, it seeks to achieve two goals. First, it's around gender equity in systems that have been traditionally oriented toward men. As Mr. Cabetta mentioned, the number of women in Maine's prisons has grown substantially in recent years, and those systems are really developed for and frankly by men, and that means there are sort of male-oriented defaults within those systems. So we really particularly appreciate the expansion of people representing the needs of women in the Board of Visitors and these explicit Board of Visitors for Women's Services, as well as the other acknowledgements around women's experience, such as during transportation. The other key aspect of the bill that we lift up is the support for caregiving and connection between incarcerated people and their children. As Senator DeChambeau mentioned, this is not specific to women, although women are traditionally caregivers in our communities and cultures, but we know everyone can give care. We also know that incarcerated women in particular have substantially higher levels of lifetime trauma, sexual and domestic violence than the general public. These experiences are often connected to the reasons why they are incarcerated, often drug involvement, and these combined can really interrupt or challenge people's best efforts at parenting. We've already heard that incarceration adds a further layer of harm to these families, and that separation of a parent is a key experience that can affect people over a lifetime. So carceral systems that create barriers between children and parents contribute to intergenerational trauma. And we think that this annual report and the improved visitation standards can really help to address and provide accountability in that realm. We are in strong support of the bill and its improvements, but also acknowledge that it does not replace the fact that we simply must start recognizing the intersection of trauma and substance use disorder and gender equity, and how these issues combined with our policy around drug use and possession mean that we are sending people to a place that is not a healing place for trauma. So we will continue to advocate for other systems that will chip away on that side of the work. And in the meantime, are grateful to Representative Talbot Ross for her thoughtful work on 1721 and a range of other bills like this. So we hope you will vote ought to pass. I'm happy to answer your questions.
Any questions of Ms. Bray? Seeing none, thank you for your testimony.
Thank you.
I now have Jan Collins.
Senator DeChambeau, Representative Warren, and honorable members of the Criminal Justice and Public Safety Committees. My name is Jan Collins, and I am Assistant Director for Maine Prisoner Advocacy Coalition. I'm here today to ask your support for LD 1721, an act regarding the dignity for women in correctional facilities. MPAC's mission is to support Maine's incarcerated citizens, their families, and friends in their struggle with Maine's criminal justice system. Our purpose is to reduce Maine's use of incarceration by creating a criminal justice system that is ethical, humane, and restorative in nature. For most of the history of the correctional system in Maine, women residents were a distinct rarity. Due to the current opioid crisis, Maine has been incarcerating an unexpectedly large number of women for drug-related offenses. Prisons, jails, social services, and communities in general have been ill-prepared for this influx. Women in carceral facilities experience rates of sexual victimization at 4 times the rate of men. Because they are more susceptible to victimization, care should be taken to minimize the opportunities. More female corrections officers should be hired for women's facilities or women within facilities. Female officers should accompany women to medical appointments, and women with lived experience should have a seat at the Board of Visitors. Children are the unintended victims of our incarceration of their parents. More thought needs to be given to mitigating the harm done to children and families. Children with incarcerated fathers, particularly African American children, are 3 times more likely to become homeless and move more frequently than their peers. 1 in 4 children of incarcerated parents were under the age of 5, and more than 75% in low-income households. Children with incarcerated parents are 2 times as likely to develop learning disabilities or anxiety, just as Wendy just spoke about. Children with incarcerated parents are 3 times more likely to suffer depression or behavioral problems. Children, especially young children, don't necessarily say how they feel. They act it out. Kids of incarcerated mothers, in particular, are at greater risk of dropping out of school. In Maine, 1 in 14 children has had 1 or more incarcerated parents. This bill is a first step in recognizing that our penchant for over-incarceration has consequences for children, families, and our communities. Ultimately, we must find a way to rehabilitate parents in a community setting that allows for the development of parental skills while parents are receiving medical services for addiction and/or critical mental health issues. If we do not, we risk perpetuating damaging trauma in the next generation. I speak from experience. My father's incarceration thrust my family into homelessness and poverty. It was the defining event of my childhood and of my siblings, and it has lasting consequences. Please support LD 1721, an act regarding dignity for women in correctional facilities. Thank you. And I'm welcome questions.
Any questions of Ms. Collins? Seeing none, thank you, Ms. Collins.
Thank you.
Anyone else who wish to speak in support of this bill? Seeing none in the attendees list, and no new names here, I will then ask for those in opposition of LD 1721.
Sheriff Trafton was in opposition, but he's kind of disappeared for a second.
Okay. Are we waiting for him, Darlene?
Well, I've got him up on the screen, but he's walked away from his, here he comes. He's on the phone. He's coming.
Multitasking.
Yes, we all are, aren't we?
Welcome, Sheriff Trafton.
Thank you. I apologize for that. Trying to do too many
Business
things
as-
at once
yeah.
here.
Business as usual. Go right ahead.
Okay, Senator DeChambeau, Representative Warren, and esteemed members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Jeff Trafton, and I'm the sheriff here in Waldo County, and I'm here on behalf of the Maine Sheriff's Association. The Maine Sheriffs discussed this bill and voted to oppose LD 721, an act regarding dignity for women in correctional facilities. Now, we want to be very, very clear that the Maine Sheriffs are fully invested in ensuring that our residents, including female residents, are cared for with dignity. When we met to discuss this bill, we were united in the concern that opposing a bill mandating dignity for women in our jails could be misinterpreted. All 15 jails strive to promote an environment of dignity for our female residents and will continue to make this a priority. Our opposition comes from a statewide staffing crisis that prevents us from the ability to ensure providing a female officer during transportation to and from medical appointments. While this expectation to provide female officers during medical appointments may seem feasible, with some counties facing staffing shortages of up to 50%, it's simply unattainable at this time. And the other example that I want to give for that too is if a jail has a resident that is a female and they have no female corrections officers, then they would have to be transferred to a jail in another county, and that would further victimize the family and the female resident and separate them from their families and their loved ones. And we don't want to see that happen. So while the Maine Sheriffs understand and admire the intent of this bill, we simply cannot support the language that mandates a service that we're unable to provide at this time. If the sponsor were to remove this mandate, the sheriffs would be happy to reevaluate our position, but at this time, we cannot support this bill as written. Maine Sheriffs appreciate the opportunity to present this to this committee, and I would be happy to answer any questions you may have.
Representative Warren, followed by Representative Reckett.
Thank you, Madam Chair. Thank you, Sheriff, for being here. Just a quick question for you. What are the rules around who can provide transportation to medical appointments from the county jails?
Well, it depends. A lot of it depends on the classification of the resident. In my facility, all of our residents are minimum security. So especially in our reentry center, and I'm able to, we have contracts with the Volunteers of America, and they can provide transportation for our residents. Unfortunately, our reentry center is an all male facility. So that wouldn't help us in this situation. But then as the classification increases, it becomes more difficult and would have to be a certified corrections officer that provides that transport.
Okay, so when we think about, thank you for the answer. So for you, it sounds like it wouldn't be an issue, the transportation, because you have contracts with Volunteers of America to transport folks. But how many residents are we talking about that would happen to be both women and the classification needed to require a corrections officer?
Unfortunately, I don't have that information from the other 14 facilities in the state. I apologize for that.
Is that something that you guys can access with your bar system, or is that information that you keep track of, just to give us a snapshot?
I believe we could put that together, and I'll work on that with our executive director and try and provide that for you.
That would be really helpful, because it just seems like, I mean, if this is the only thing that's blocking you all on this bill, maybe there could be a policy solution that's arrived at, because it seems like not not a large sort of, blockage to overcome if we all put our heads together. So thank you for that. Thank you.
Representative Reckitt, followed by Representative Pickett. You're muted. Thank you.
I too was a little kerfluffled by the title of this bill, but I'm also aware of how darn difficult it is to change the title of a bill once it's there. I mean, I tried last session myself to change the title of one of my bills that really didn't reflect what we were doing, and I never did succeed. So my point is, I think that there is more to this bill than women in correctional facilities. There is support and access for visitation with parents of either of any gender, and I think that we need to figure out a way, and I'm sure that Representative Talbot Ross is interested in doing this as well. Find a way to convey that this bill is not entirely about women, but there are critical pieces about women in here. So I think that I'm empathetic to your concern, Sheriff, because I too don't like the title, but I don't even just like it on the basis of women's stuff. But I think it's important that we find a way to make sure that when the first time people see this bill,
Thank you.
they don't immediately.
Anyone want to respond?
They don't
I
immediately.
think she froze up, right? I don't know if she.
I don't think so, but I'm done anyway. So.
I think we may have lost Senator DeChambeau for a second. So Representative Pickett.
Yes, thank you, Madam Chair. Sheriff Trafton, I know you've spoke about the transportation part and that kind of stuff in your testimony and what we're discussing, but I wanted to ask you this as a one of the 15 county jails, and you have female prisoners at times, I'm sure. I don't know if you have any at the present time, but you have female prisoners, and you also have a visitation program that's set up, I'm sure, at your facility. So my question to you would be this: if you have a person in your facility that is a female prisoner, as this bill, as it's written right now, anyways, is talking about, and they are allowed to have visitation. How does that work? Are they allowed to have visitation with their children if their children come? How does that work right now in your jail and as far as you know for the county jail system we have right now?
Well, as I said earlier, the main focus of our facility in Waldo County is reentry, men's reentry. That is a 32-bed facility. So, and it's all minimum security residents. So visitations are it's very liberal. We actually allow them. We have picnic tables set up outside of our facility, and they are able to visit with families, children, and other relatives. And so, and again, our whole focus is to get them ready to move back into society. In our holding facility, our holding facility and booking facility is very small. It's only 6 cells. And normally the folks are only there sometimes, if they make bail, they're only there for a very short time. If they're not able to make bail, they're there sometimes for as little as 24 and up to 72 hours. And we only normally only set up visitations in the booking and holding facility if there's exigent circumstances, like and I'm having trouble coming up with an example, but we have in the past done that, and we have a visiting room inside the facility that's for both all genders, and again, it's that again also is contingent upon the classification of that person in holding. If it's if it's something where they're a security risk and they're a high classification, then we have to be, it makes it much more difficult. It's much more staff intensive. So there's no one size that fits all, I guess is what I'm trying to say. And I know that the other facilities, especially the larger facilities like, Somerset, York County, Cumberland County, I don't have the specifics about their visitation schedules. I know that they all have visitation, and those larger facilities have people of minimum, medium, and maximum security, and visitation depends heavily on that classification. I hope that answers your question.
Yes. Follow up, Madam Chair.
Yes, go right ahead.
Thank you. And so where you're speaking in behalf of the MSA, the Maine Sheriff's Association, am I right to understand from what you've just said that in all of the facilities, all 15 facilities, there are rules for visitation in the jails, and that if those rules are met, that there is, when a female inmate is in one of those jails and they are allowed visitation, and visitation is not restrictive to children. In other words, children can come and visit in those facilities, all 15 of them. It depends. I know not one size doesn't fit all. I understand that, but using the policy and stuff throughout the county jails throughout our state, they all have a provision for females to be able to visit with their children at a certain point. Is that correct?
Well, and I hesitate to speak for all the other 14 facilities, but I do know that we all have some level of visitation in our programs. And I know many of the facilities now can do video visitations if there's a security classification or the security risk is a problem. We have the options here in our facility. We have the iPads, and they can do video visits, and that helps keep families closer and keeps them connected while their loved ones are incarcerated. So I don't have specific numbers for you, sir, but there is a combination of those kinds of programs throughout the state. I do know that much.
Madam Chair?
You have a follow-up?
I don't want another question. I just, for the work session, I just would like to have where MSA is being represented here, if we could just get a answer to that question. Doesn't have to be anything, just so that we know that there is availability of female inmates in our county jails to be able to have visitation of some sort with their family members, including their children. I think that's a really important issue, especially as to some of the testimony that we've heard, and especially to that little girl's point, which we heard. I think that's a very important issue. Thank you.
Senator Seaway, followed by Representative Rickett.
Thank you, Madam Chair. Sheriff Trafton, I just got a question. I understand what the point of this bill is, and I think it's a good gesture and everything. And I'm just wondering, just from the Maine Sheriff's Association standpoint, I'm just asking if this bill would interrupt what the court's decisions are or not. Would there be any conflict between the courts and the jails? I'm just, because sometimes courts have a different outlook than what may be visible to the sheriffs. You know what I'm saying?
The only conflict that comes to mind that I could think of would be if there's some kind of a court order, like maybe a restraining order, protection order, where a child may be a victim, and which would prevent contact, if there's bail conditions that would prevent contact from children or certain people, those are the only conflicts I can think of. And those would apply across the board. So, so I don't think this specific bill in what I've read would have any effect there unless an order was in place, and then we would enforce that.
Because I just, you know, my son adopted 2 children that was kind of like in these positions with the family. And I just can see where maybe, and the courts looked at it as like it was harmful to the children if they went and visited. And so I didn't know if there was some conflict or anything, that's all. Thank you.
Representative Reckitt?
Yes, I think since we've asked the sheriffs to try to give us the information on the visitation issues around the state, I frankly am more concerned in this bill with understanding what those policies are on the state level at the Maine Correctional Center and other facilities run by DOC. So I'm sort of wanting to know that information, at least for a couple of the facilities in the state when we go to work sessions. So I don't know who could provide that. I presume somebody at DOC could do that pretty easily. So thank you.
Did I hear you ask? I'm sorry, I missed probably the first part. It's visitation you're asking?
Yes, if we're talking about making sure that visitation happens, I want to know how that works in the prison system, not just in the jail system. Because I think particularly in light of the testimony from, I forget her last name, but Wendy.
I think Director Wolfhard, Amanda.
Yes, yeah, Amanda would be good to do
Okay.
that, yeah. So thank you very much.
Thank you. I have a question for you, Sheriff Trafton. You do have a pre-release, and I will give you a plug, a very good pre-release for men. I've known it for a long time. And you said you have about 8 cells. If you have, are the cells all like in one area? I'm wondering where a woman, and a lot of times it'll probably be 6 men and 1 woman coming in. What do you do in those circumstances?
What we have some combination holding cells that are in one area, and they're split up into individuals, but they're still in the same area. And then we have 2 individual cells that are separated from that. So if we have just 1 female resident, then we can put that female in the holding cell so she has privacy. But if we have more, sometimes we have 2 or 3 female residents. It doesn't happen that often, but it has happened. They can be in the area with the community cells. So and again, this is just a booking facility. The actual the reentry center has, those are day rooms. They don't have cells. They're in open dorm type areas. So
And holding period could be how long?
it's supposed to be not more than 72 hours. And
Thank you. Yeah. I think any general public person listening in, Waldo is very unique in that circumstance. So thank you.
Thank you.
So anyone else wishing to speak in opposition to this bill? I don't see any. Anyone wishing to testify neither for nor against? I thought there were some. We'll see. No one?
No one.
I believe there may be testimony to that. I think I saw one. All right, I will close this public hearing on 1721 to a close. And again, Representative Warren, I think work session may be next week or in a couple of weeks. I appreciate you looking that up.
Yep, next Friday, 1-ish.
Yeah. Along with other one-ish.
Everything is ish.
Okay. Ladies and gentlemen, I am looking at 12:37. We have 2 work sessions. One of them is yours, Representative Warren. Should we take a 20-minute break?
We
to
have
at
one
least stretch?
We have one more public hearing
Yeah.
and 2
Oh, I
work-
missed that one.
and 2 work sessions. I'm fine to do a very quick lunch break and then do our public hearing.
Good,
If people are
could we-
needing.
Could we do?
Excuse me, could I just go 1 second?
Go ahead,
Let me
sorry.
finish thank you. If folks are feeling like they need to take a break now, I'm just wondering if we could keep it to around 20 minutes.
Yeah.
I'd really like us to finish by 3 today.
Representative Pickett?
Yeah, I was thinking where we only got one public hearing left and there are people waiting for that. Maybe if we just did that public hearing right now and then took that very short break afterwards, come back and do the 2 work sessions in the study, the bill studies. That would be my suggestion.
I second that. I love that idea. If others, and Senator, if you need to take a quick break, I could cover for you for a few minutes and we'll get the public hearing going.
I think I will take that break, okay?
Okay, let's do the public hearing. Thank you.
Great.
So next up, we have LD 1552, and we have the sponsor, Representative Talbot Ross, with us. Thank you.
Thank you, Madam Chair. Senator DeChambeau, Representative Warren, and the distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Rachel Talbot Ross. It's good to be with you again. I represent House District 40, which is part of Portland. I want to thank you for the opportunity to present LD 1552, an act to provide reentry services to persons reentering the community after incarceration. At the time this bill was submitted, it felt necessary to not only address the acute needs of those reintegrating into society through legislation, but to codify the tools and pathways that would lower the state's recidivism rate. Because I believe in the power of rehabilitation and restorative justice, I have submitted a reentry bill every one of the 3 sessions in which I have served. However, today feels like it is a different time in which significant work is taking place on reentry, both inside our correctional facilities and in collaborative, intersectional ways in communities across the state. That brings the Maine Department of Corrections in direct relationship with groups that include, but are not limited to, the Maine Prisoner Reentry Network, the Maine Prisoner Advocacy Coalition, and the Maine Recovery Advocacy Project. Their combined efforts are making a real difference in people's lives. Therefore, I believe we need to respect this ongoing work, particularly the elements that are being led by former justice-involved individuals, and give them time before moving this legislation forward. But there remains the need to confront our overt reliance of incarceration. It is my hope we can take this opportunity to utilize the bill to expand on the work many of you have been leading to reduce the use and pathways to incarceration. To that end, we are working on an amendment to limit which violations of conditions of release can serve as the basis for a Class E crime of violation of condition of release under 15 MRSA subsection 1092. To be clear, this would not change or repeal any of the permitted conditions of release currently under the bail code that can be set by the court as part of a person's bail perimeters. According to Pew Research Foundation, incarcerating people for technical violations has contributed to high state incarceration rates while doing little to enhance public safety, especially as a response to behavior that is not in fact a crime. This is currently true in Maine, where the Council of State Governments found that 3,222 case filings in fiscal year 2019 were for violation of conditions of release. I've attached that information for you to my testimony. Both Pew and CSG identified this as an important area for policy reform. The proposed amendment, which I've attached to my testimony, would rename the bill an act regarding violations of certain conditions of release under the Maine Bail Code. Under the current Maine Bail Code, a defendant who violates any condition of release is guilty of the Class E crime of violation of a condition of release. The amendment provides that such an individual is guilty of violation of a condition of release only if the condition of release violated required the defendant to do 4 things. 1, avoid all contact with or only contact at specific times a victim of the alleged crime, potential witness, or family or household member of the crime. 2, refrain from possessing a firearm or another weapon. 3, enter and remain in a long-term residential facility for the treatment of substance use disorder. Or 4, return to custody for specified hours following release for work, school, or other limited purposes. I believe the data is clear. Reforming the Maine Bail Code to limit the use of violation of conditions of release will help address our over-reliance on incarceration, a practice that harms individuals and communities while overburdening our system and costing taxpayer dollars, while continuing to protect public safety. I just want to end by letting you know that I plan to continue to work on this amendment. I think this is a necessary first step, but before the work session, I really pledge to work with the Department of Public Safety, the Maine Prosecutors Association, the sheriffs, our friends within the domestic violence and sexual assault advocacy community, and impacted stakeholders to really discuss this measure and to further refine the amendment in ways that we will honor public safety, respect public safety, but also reduce our reliance on incarceration due to technical violations that many times have nothing to do with the underlying charge. I'll leave it at that and open it up for some discussion before you break for your lunch.
Thank you, Representative Talbot Ross, for bringing this forward. And we'll start with Representative Galgay-Reckett.
Hi, thank you, Representative Talbot Ross. I'm looking at this and hearing your words, and I absolutely love the path you're on. But I think that before we turn around and make it automatically next week that we're going to do this, I think that's a timeline that's a little crazy and is going to cause us to next week meet and then delay another week. So I'd like to suggest to the chairs that we not do that in a one week turnaround, but we do at least 2 weeks so that the sponsor will have sufficient time to consult with all the people that she has pledged to do so.
Thank you.
I think that's a great suggestion, and I'll talk to Senator DeChambeau about that, and we'll possibly move that. We've already piled a bunch on for next week, so I think that's a great suggestion. Thank you.
You're welcome.
Senator Searway. Oh, Senator Searway, you're on mute.
Thank you, Madam Chair. Good afternoon, Representative Ross. I just wanted to ask if there's a list of stakeholders that is going to be involved, including like the judges and probation office. Probably going to need the law enforcement. A lot of those stakeholders have to be involved in this because I can see a lot of big issues on this. The big question I have is, if you take away these things that are listed as conditional release, a lot of times it's protections, but not only it keeps the person from getting into trouble, but also it keeps the others from filing more complaints and that sort of thing. and whatever. And so I think this could actually cause more disruption than it's going to help. And I'm very concerned about that. And so I don't know if there's any other states that have done this and how that's working. If you can show some evidence of if it's helped or caused more issues. And it just seems like it does. I don't know what your thought is on this.
Well, thank you, Senator. I share concerns as well, and certainly plan to bring the stakeholders that you just named together. I want to appreciate Representative Reckitt's suggestion to give me a little bit of time to do that. But most definitely will bring law enforcement to the table to see, to make sure that we can agree on a good pathway forward. I'm committed to do that, and I promise you that I will. I can bring some data to the work session. I can even provide it prior to the work session about the evidence-based happening all across this country around making these changes and showing significant improvement and reducing our reliance on incarceration for technical violations. Many times, they have nothing to do with the underlying charge. And so from a pre-conviction standpoint, for folks who haven't even been convicted of a crime, they haven't been found guilty of any offense, having these technical violations that amount to another charge does very little to affect the change that is sought. So I can bring that information to the work session for you and certainly hear your concerns.
Yeah, it's just a judge's discretion on this many times, because I used to be a bailiff, and many times the judge would, say, well, why are you waiting for trial? Because they may say not guilty at the time. They may even know they're guilty, but they may say not guilty just to buy time to get all the facts and all that, and also deals and whatever. But anyway, so the judge may put these constraints on just for safety for the individuals and also for other factors. But I'm just concerned about that. So I just want to know from the judge's standpoint if this is taken away their ability to do their discretion. That's what
Senator,
I
I think you asked your question and she answered it, and we'll get to that at the work session. Thank you.
Thank you, Senator.
Any other questions for Representative Talbot Ross? Seeing none, are there any legislators here to testify on the amendment to this bill? Seeing none, I'm now taking testimony in support of, oh, yep. Okay, great. In support of the amendment. And I see that we have DA Sarbeck and Mr. Cabetta. I'll let you do your thing, Darlene, with how you bring people in, okay?
Okay, I've got Leslie Runzer in right now, and then we can do the others.
Thank you. Good afternoon, Ms. Runzer and DA Sarbeck. We're going to go in that order to start. And you're on mute, Ms. Runzer.
Thank you. Good afternoon, Senator Deschambault, Representative Warren, and members of the Criminal Justice and Public Safety Committee. My name is Leslie Runzer, and I live in South Portland, a proud constituent of Representative Rickett. The testimony that I prepared today on behalf of the Maine Unitarian Universalist State Advocacy Network relates to the reentry services bill that's been replaced. And since that testimony is no longer relevant, I won't take up any one of your time. So thank you.
Oh, thank you very much. Thank you for being here.
Of course.
Thank you. Then we'll go to DA Sarbeck. Thank you for being here. Good to see you.
Good to see you, Representative Warren, and every member of the committee. My name is Jonathan Sarbeck. I'm the district attorney here in Cumberland County. Thank you, everybody, for having me. And I'm here in support of LD 1554, I believe it is. And this 1552. This was a LD that Representative Talbot Ross had reached out to me about looking into and a couple days ago. And I have spoken. I'm not here in support, or I'm not here representing the Maine Prosecutors Association. Quite frankly, we have not had discussions about our view on this. But quite frankly, as written, what this would do would basically limit the ability of a prosecutor or law enforcement to charge a Class E violation of condition of release under the bail code to those four subsections that are listed in the bail code as written. As of now, the violations of conditions of release can be a new crime for bail on an existing crime or allegation if somebody violates all of those subsections that are written there. What this would do is limit what a new charge would be for violations of conditions of release to those sections. What it doesn't do is change or affect a prosecutor's ability to file a motion to revoke bail on an existing charge if somebody is to violate those conditions. So to address Senator Searway's question with regards to limiting a judge's ability, quite frankly, this as written would not limit a judge's ability when it comes to a motion to revoke if somebody's to violate one of those conditions of release, because the state would still have the ability to revoke that person's bail if there's an allegation that that person violated it. But what would happen is that it would limit the discretion of a prosecutor to file a new charge of VCR only to those charges or only to those subsections listed. So hopefully I've not made that completely unclear, but I'm here to answer some questions if anybody has some with regards to the bill as written.
Thank you, DA Sarbeck. Senator Searway.
Thank you, Madam Chair. Thank you for coming. I think not just to revoke was the issue, but also if a judge decided to put the conditions on during a period of time until they came back to court or whatever. That's the other piece that I'm concerned about, because this eliminates those conditions.
I think what it does is it eliminates the ability for a prosecutor to file a violation of conditions of release. So for instance, if you had an individual who's alleged to have been committing car burglaries during the night, and the person gets arrested, they're placed on bail, the court places them on a restriction of a curfew, that person's not allowed to leave the house between 6 p.m. and 6 a.m. Then that person is found at 2 in the morning on the street. Under what the law is now is that person can be, the prosecutor can file a motion to revoke for violating those conditions of release. But what we could also do is file a new charge of violation of a condition of release, which would be a Class E offense. And so what this would do is basically say, you can still file your motion to revoke. What you can't do is file a new crime of violation of condition of release for being for not abiding by that present condition by the court.
So it's basically upping the crime?
No, it's actually
from an E to a D?
No, it is not doing that. All it's so, and I'm sorry if I'm not explaining this in a way, because this is kind of my everyday. So sometimes I think that people speak the exact language I do. So I apologize if I'm not being clear. So if somebody's on a bail for a burglary and there's a condition that they be on a curfew, and then they violate that, the motion to revoke would be on that existing burglary charge. And then the court would basically, if the prosecutor said, we want this person held without bail, or we want more conditions in place, and it would be up to the judge to decide whether or not that person's bail gets revoked on the existing charge. Now, what the prosecutors can do now is file a new charge of violation of condition of release for the violation of that curfew, and that creates a new criminal case, a new allegation separate from the burglary charge. But what this doesn't do is it doesn't affect if there's a victim of domestic violence, for instance, that's contacted then the prosecutors could still violate that person on the existing charge that alleges that domestic violence, that they shouldn't be contacting the victim. And we still would be able to file a new charge of violation of condition of release because that paragraph, that subsection is left out and does, it still exists under the statute of the prosecutor being able to file a new charge for that violation of condition of release.
So why wouldn't you want them to be held accountable and not charge them?
I mean, I don't, that's sort of a policy. No, it's a good question. It's a policy decision that's up to the legislature. I can tell you that with VCRs, more likely than not, those are cases where the burglary is going to be the charge that we're going to be focusing on, not the violation of condition of release. There are definitely circumstances, especially in domestic violence cases, where a victim's contacted that we take very seriously, or somebody has a firearm when they're not supposed to. But those are definitely Class E's that we look at more closely. I think the important thing in this situation is that if we're looking at sort of shrinking the umbrella of criminal activity, that would be one way to do that. And I can tell you, Senator Siri, because I think you asked this question, I worked as a prosecutor in Massachusetts for 5.5 years. Massachusetts does not have a separate statute when it comes to violation of condition of release, that we only do actually look at what the conditions of that person's bail are and if that person violates. So for instance, if it's a person who's been accused of multiple drunk driving offenses, and we think that that person should not be drinking alcohol because their substance use disorder is so severe that it becomes a public safety risk that they might be behind the wheel if they are consuming alcohol, we would ask for a condition that they not be allowed to drink. Now, it's not against the law for them to possess alcohol, so there wouldn't be a new crime of possessing alcohol. But if they did violate those conditions of release, we would file a motion to revoke on that existing case.
Thank you. Senator, how about we save the questions for the work session? We'll definitely have a chance to discuss this more. Thank you, DA Sarbeck. Next up, I have Mr. Cabetta.
Thank you, Representative Warren, Senator DeChambeau, and distinguished members of the committee. Hello again. I'm Michael Cabetta, Policy Counsel for the ACLU of Maine. And on behalf of our members, I urge you to support this bill as amended. We've been working for years to reform our state's pretrial justice system. We've seen how even one day behind bars can lead to the loss of jobs, child custody, and a bed in a recovery house. We also have done a lot of work to address the collateral consequences of convictions in the form of criminal records. These records can hinder people's future success. This bill addresses some of our concerns about both of those things by changing Maine's practice of creating a separate crime for violations of conditions of release. Maine is only one of 7 states across the country where violations of pretrial release, other than failure to appear in court, are considered an entirely new crime. The other 6 states are Alaska, Colorado, Connecticut, Delaware, Illinois, and Wisconsin. And trust me, they're not great company. In other states, if a person violates a bail condition and the district attorney feels the violation has been egregious, they can simply do what DA Sarbeck just said and file a motion to revoke bail and address the violation without adding any extra criminal charge to a person's record. In those states, the person would lose their freedom and go back to jail. That would be the way prosecutors here would address bail conditions should this bill pass. 43 other states are able to address violations of conditions of release without charging people with new crimes. We believe Maine can surely do this as well. Both violent and property crimes in this state have dropped over the last decade. Property crimes have dropped 44%, and violent crime has dropped 3%. Yet arrests in our state have only dropped by 17%. Violations of conditions of release account for more than 1/5 of the arrests in our state every year. Approximately 2/3 of people in Maine's jails are there pre-trial. We must lower the number of arrests made every year so that we're not unnecessarily arresting or jailing people who can be held accountable in ways other than jail time. This bill proposes a good approach to this issue, and we urge you to support it. I thank you for your time and attention, even this close to the lunch hour. And I'm happy to try to answer questions. Thank you all.
Thank you, Mr. Cabetta. Questions for Mr. Cabetta? Seeing none, thank you very much for your testimony. Next up, we have Ms. Smith. Thank you for being here.
Thank you, Senator DeChambeau, Representative Warren, and members of the Criminal Justice and Public Safety Committee. My name is Wendy Smith Allen, and I'm from Milford, Maine. I'm the Restorative Justice Institute of Maine's Young Adult Diversion Program and Policy and Advocacy Lead, a coordinator for Maine Prisoner Advocacy Coalition, and an organizer for Maine Recovery Advocacy Project. I'm also a woman in long-term recovery and rehabilitation from the criminal justice system and substance use disorder. I'm here today in full support of the amended version of LD 1552, an act to provide reentry services to persons reentering the community after incarceration. Violations that send people back to jail, also called violating conditions of release or probation violations, Class E offense, are mind-boggling to me. I myself have been personally affected by these minor violations, resulting in a criminal record far worse than what it should be, causing more barriers for a successful rehabilitated life. I was sent to jail many times for violations that never included new criminal charges. One violation was being around a person on probation out in public when it was not even known to me. I was taken to jail for being 10 minutes late for a curfew while trying to get home from a cancer treatment. I was left in a holding cell inside jail for 13 days until I could see a judge, who thankfully released me, but only with a guilty plea. During this time, I lost my housing and I was left to release to a homeless shelter, a wet shelter at that, meaning that people can come in under the influence of substances. I was not only fighting for my life, but fighting for my recovery as well. This situation caused a relapse and yet again another violation and a trip to jail. This time I spent over 30 days in jail before I saw a judge, where I was sentenced to 90 days to this Class E violation. I was unable to receive my cancer treatments while inside, and once released had no place to live and had to go to a weekly hotel mandated as a condition in a high drug activity side of town. I no longer had a job and struggled to pay $350 a week that the motel required. This was mandated in my conditions. Having lost my job, it caused me to use survivor skills and go back to what I knew to make money, resulting in a lengthy prison sentence for picking up new charges. Having these minor violations result in high recidivism rates without any safety threats to the community and prohibits those that are trying to rehabilitate to move forward. Those that have a violation of a dirty urine should be offered treatment, not jail time. Sending someone to jail on these little technical violations, such as 10 minutes past curfew, or speaking to another person that's on probation and being seen by law enforcement and immediately taken to jail, are setting people up to fail. So I am asking and urging you all to vote ought to pass for the LD 1552 as amended. Thank you.
Thank you, Ms. Smith. Any questions? Seeing none, thank you. Next up, I have Jay Davis and then Tina Neto.
Good afternoon, and thank you, Senator DeChambeau, Representative Warren, and members of the Criminal Justice and Public Safety Committee. I am Jay Davis. I live in Belfast, and I speak in support of the use of reentry programs and for LD 1552. Belfast has been home to the Maine Coastal Regional Reentry Center for more than a decade, the only such facility for incarcerated males in Maine. As a volunteer for the Restorative Justice Project, I have spent much time in the center and have gotten to know both the programs offered and the men who benefited from them. I know too that the community has benefited from the residents' volunteer work on many well-attended events. All the residents are either moderate or high risks of reoffending, mostly because of substance use issues. At MCRRC, their days are filled with classes and counseling as they work toward privileges that can give them regular access to the community, paid employment, and a hint of the freedom that will be theirs when their stay is completed. I believe that the goal of any type of incarceration must be to have the offender leave in a better position than when they entered. We all know that external factors such as poverty, lack of education, bad parenting, substance use, etc., are the root causes of much crime. By carefully and meaningfully working to improve their prospects, the chances of becoming productive and non-criminal citizens is seriously improved. I know LD 1552 has been amended to deal with a technical aspect of jail and bail. I hope that the opportunity to work on the bill and even think about reentry will give support to more comprehensive reforms in the future. MCRRC evolved from the old Waldo County Jail. How about 3 more reentry centers in current jails in the future? Thank you, and please support LD 1552.
Thank you, Mr. Davis. Do we have any questions? Seeing none, thank you very much for your testimony.
Thank you.
Next up, I have Tina Netta. Welcome.
Thank you, Representative Warren, and good afternoon, everyone. My name is Tina Nato. I am the Executive Director of the Maine Association of Criminal Defense Lawyers, and it is in that capacity in which I am speaking today in support of the amended version of this bill. I apologize, I don't have written testimony. This amended bill came kind of as a surprise to me as well this morning. A pleasant surprise because I do think it is a good bill, but I usually am not so unprepared to testify. I deal with the bail code every day in my role as a defense attorney, arguing for bail, arguing against certain conditions being imposed for my clients. But I can tell you, and I think the stats speak for themselves as Mr. Cabetta recited them, about 1/5 of our arrests in the state of Maine right now are for violations of conditions of release, not for new crimes, but for violating conditions of release. That's a lot. Currently, we have 27,000 cases pending in the unified criminal dockets. Typically, we have about 16,000. So we are at way beyond capacity in our court system. And a lot of those cases, as you've heard, I think some 3,000 or so annually, are with violation of condition of release as the top count. Not a new crime, but violating conditions. So to clarify something, I think that was a little confusing earlier. This does not prevent a judge from imposing the conditions of release that are currently in statute. That absolutely can still happen. It does not impose any restrictions on that. What it does is it restricts what violations could be considered crimes for which you can be arrested and prosecuted. That's the difference. I think it is telling that 43 states do not have violation of conditions of release as a separate crime. They deal with it in other ways. Even Massachusetts, as DA Starbeck mentioned, deal with it by moving to revoke bail. If someone is violating their conditions in a way that impinges upon public safety, puts people at risk, or it just shows this person cannot be released safely into the community, prosecutors can, do, and will file motions to revoke bail. This shrinks the universe of offenses for which somebody can be arrested and prosecuted. In COVID times, that certainly matters because we are overrun. I think in regular times, it also matters because we are still massively incarcerating people for low-level offenses in Maine. Approximately 5% of all offenses in Maine for which people are arrested are considered violent offenses. These offenses, the vast majority of these violation of conditions of release, are not violent. The one that could still be a crime that I think is the most serious, and I would agree with, is any contact with a victim or family member if prohibited. That would still be a crime under this proposal. That is the one condition really that's about public safety. So we're not taking that tool away from law enforcement or prosecutors. We're just saying the rest of it can be dealt with in more creative ways that doesn't lead to people getting locked up or having stacked charges. So I'm happy to answer questions now. I definitely know how this stuff works, and I'm happy to try to explain it in English if possible. I know sometimes we speak in code. I'm trying very hard not to do that. I don't want to speak like a lawyer when I can break it down for you a lot easier. So if there's any questions now, happy to discuss work session as well.
Thank you. I really appreciate your attempts to help us with the language. My brain kind of shuts off sometimes because I don't understand.
Yeah.
I'd love it if you could be here for the work session. And I think once I talk to my co-chair, I think we're going to try to move it to March 4th, which is 2 weeks from today. So that would be really helpful. Any questions for Attorney Neto? Not seeing any. Thank you again very much.
Thank you all. Have a great Friday.
Thank you. Anyone else here to testify in support? Oh, excuse me. I see we have Andrea Mancuso here. Not sure if she was here for this bill or the next bill or the works.
This one, but I think I've signed up neither for nor against.
Okay, perfect. Let me do one more check. Thank you, Andrea. Thank you. Anyone else here to testify in support of the amended version of LD 1552? And I'm not seeing anyone. I feel a bit concerned, Darlene, that I have someone on the phone and I want to make sure I don't miss them. Do you have the ability to text them and just make sure, or I don't know how we get a hold of somebody?
I don't, but I just allowed them to talk so they can at least tell us who they are.
Okay, great.
It might take a second.
Thank you. So welcome to the person on the phone. We want to make sure we don't miss you. And are you here to testify on LD 1552? Again, I'll do one more call for the persons whose phone number ends in 6012 and is here with us. And I just want to make sure if you're here to testify, you have the opportunity. Okay, I'm going to now ask for anyone here to testify in opposition to the amended version of LD 1552. Please raise your hand. I'm seeing no hands. And now let's move to anyone here to testify neither for nor against. And we're going to begin with Andrea Mancuso. And if there's anyone else here to testify neither for nor against LD 1552, please raise your hand and we'll have you moved in. Hi, Andrea. Thank you for being here.
Good afternoon, Representative Warren. Representative Warren, distinguished members of the committee, my name is Andrea Mancuso. I'm the Public Policy Director for the Maine Coalition to End Domestic Violence, and I'm here today to talk to you neither for nor against the amendment that's been proposed on behalf of our network. I'll echo Attorney Nadow's apologies for not having written comments for you today, but did want to mention over the last several legislative sessions, MCDV has been happy to be at the table and in conversation with Representative Talbot Ross and many of the other folks you've heard from this morning, looking at how our use of violations of conditions of release in Maine might be modified to right size the criminal legal response with the usage and the focus of this part of our criminal code on those situations that are most likely to have a real impact on safety, both public safety and victim safety. You've heard how many charges for VCRs are filed in our criminal courts each year. It's our network's understanding that the vast majority of these are not connected to domestic abuse and violence, but certainly the ones that are very important to have folded into the response of law enforcement on the ground in our experience. And we believe it's very possible to address the concerns that you've heard here this morning. There's a need to do so. And we think it can be done in a way that maintains the ability to respond to survivors in crisis. In fact, last session, MCDV worked very collaboratively with many of the folks you've heard from already this morning and Representative Talbot Ross on LD 1134, and an amendment to that bill substantially addressed the same issues raised here by the amendment presented this morning. That amendment had important nuances built into it, and we'd encourage you to take a look at that amendment. It was a really good bill, and it was unfortunately vetoed. We'd be delighted to work with interested parties to continue to move this conversation forward to try and get a good proposal to the governor's desk. I understand that's Representative Talbot Ross's intent, and we really appreciate her invitation to continue to participate in the conversation. We do have concerns that the amendment as presented would compromise the ability of the criminal legal system to respond to survivors in the moment of crisis and have consequences to safety. But we do agree that with the underlying sentiment that a reexamination and action around the use of VCRs is needed. And one thing that we think you should take a look at in LD 1134 is it proposed modifications to entirely eliminate felony level violations of conditions of release. And that's a modification to the code that our network supports. The charging enhancement that presents really brings with it increased penalties that are already available to the state by virtue of the underlying felony, and did not have the same level of impact to the crisis in the moment. But as you look to modify the Class E VCR, we urge great caution and hope you'll take the time to fully explore how this is used in practice. But thanks for the opportunity to chat with you this morning, and I'm happy to answer any questions.
Great. Thank you, Andrea. That's all very helpful information. And it sounds like you've spoken to the sponsor and you all are going to work on making those changes.
That's my understanding.
Great. That's wonderful. Any questions for Ms. Mancuso? Seeing none. Thank you very much for that testimony. I see we also have Elizabeth Simoni here to testify neither for nor against. Welcome.
Good afternoon. Thank you very much. Senator DeChambeau, Representative Warren, and distinguished members of the Joint Standing Committee for Criminal Justice and Public Safety. I am Elizabeth Simoni. I am from Augusta, Maine. I am the Executive Director of Maine Pretrial Services. I also serve on National Institute of Corrections Pretrial Executive Network. I respectfully offer testimony today, neither for nor against LD 1552. I understand that it seeks to limit which violations of condition of release can serve as the basis for Class E crimes. And I would like to tell you from our perspective at the agency, we are fully aware that so many people are returned to custody for violations of condition of release. Maine Pretrial Services tracks all of the releases that we are party to, and we also track all violations of conditions of release. We look at what the court orders and then what we witness or have probable cause to believe happened. And we routinely report out all violations that occur under our watch. We break them down into categories: new criminal conduct, failure to appear, positive drug or alcohol screens, victim contact, failure to report to us, and then the giant catch-all other. I will tell you that we're just finishing up our 2021 data, but it's looking a lot like 2020, which I'm going to use today in my comments. In 2020, our agency served 3,085 individuals. They were released for our supervision. Of those, 2,385 were pretrial defendants. The rest of them were either on some form of pre-conviction or post-conviction bail. Out of 3,085 people, 172 were found to have engaged in new criminal conduct. That's 5.5%. In 2020, that was a high number for us. We're usually around 4% or less. But I say that number so that you can see in the people that we serve, it is a smaller group that are alleged to have committed a crime. 12 of the 3,085 had victim contact that we were aware of. That's 0.39%. 18 of those 3,000 plus people failed to appear for court. That's 0.58%. So 99% appeared for court. 89 of the people just stopped having contact with us. It was a rough year because of COVID. The last statistic I'll mention to you reflects a change in how we, and with your help as legislators, view substance use disorders intersecting with criminal justice. The effect of the pandemic was wide, as we know. It affected the number of rearrests. We only had 46 people who were positive for drug and alcohol who needed to be returned to custody as determined by a judge. And I just want that to sink in for a moment, because it is reflective of how we are starting to work with people, how we mitigate risk in the community for that person, for affected others, and how we help them stay in community where recovery can happen. We are always concerned about how recovery can happen in facilities. It is very difficult. Facilities are not about the type of connection that foster recovery. So we're very serious about violations. I want this group to know we report all violations, but the statistics that I just stated to you were the violations that resulted in a request for an affidavit sworn out by our case managers. The rest of the violations were, let's mitigate risk in the community. This has been seen by the court, it's been seen by prosecutors, and we're deciding to move on and move forward. I think that's important. It varies by practitioner and it varies by jurisdiction, however. We know that most people charged with a violation of condition of release simply don't get another chance at release. We know anecdotally that those with violation of condition of release in their criminal histories are often kept incarcerated through the means of unreachable financial bail. So the collateral consequences for decisions made about VCRs and convictions thereof impact people far into the future. Many alleged violations are simply nuisances, in our respectful opinion, and do not impact public safety. They probably impact public comfort, public peace, and public enjoyment. We're now learning that some of these impact public health. So I just encourage this group to continue consideration of this. The current practices regarding VCR in Maine keeps the net wide, and people are potentially punished pre-conviction for violating conditions for a charge for which they are still presumed innocent. People struggling with addiction and other disorders cannot, without community, make change that is necessary and access help that is needed. Finally, certainly there are instances which you are considering where an instruction by the court not to contact a victim or return to a victim's home are critical to public safety and arguably within a defendant's control. This bill seems to have considered that. Thank you very much for your time today.
Thank you very much for your testimony. Representative Pickett has a question for you.
Yes, thank you, Ms. Simone, for being here. The only question I have for you, I didn't see your testimony in the queue earlier this morning when I was looking. Do you have written testimony available for us? Okay, can we get I'm really interested in the statistics you had and stuff. I think that would be important.
I will be happy to make that available to you. I'm sorry that it was not provided in writing this morning. Thank you.
Thank you.
Any other questions for Ms. Simone? Seeing none, thank you so much for being here.
Thank you. Good luck.
Thank you. Seeing no other, let me ask one more time, any more testimony neither for nor against LD 1552? Seeing none, I'm going to close the public hearing on 1552 and challenge my colleagues to a speed eating lunch. Can we do a 20-minute? Be back here at 1:40.
How about 1 o'clock? That'd be what?
That'd be impossible.
I don't mean 1 o'clock. I mean, I was going to say 2 o'clock, but that would be over half an hour. Yeah, we could probably be back by maybe quarter of.
Okay, let's say 1:45 sharp. We'll get started.
Yeah,
Thank
Friday
you.
afternoon, we'd like to get out of here.
I want out by 3, guys. I want out by 3. All right,
Okay.
1:45. Thank you. All right, I have 145. And I think, can't remember if 1604 is, I think it's Jane's bill. I mean, it's my bill, but I think Jane's the analyst on it.
Oh, I knew what you meant.
Thank you.
Believe it or not, I'm having a much better day today than yesterday.
We all have days like that, if that's helpful.
Yesterday was just awful. I'm like, oh my God, they're gonna think I'm a moron.
Never.
Nothing was working right.
We all have them.
It's not like it's the first time I've covered your committee either.
Right.
Oh, well. Mine didn't meet this week and we're not meeting next week either, so.
Oh, to be the chair of Transportation Committee or Marine Resources or.
There's quite a few of us that don't have a lot of bills this year.
Yeah.
Yeah.
That is not us. All right, so Jane, is this your bill or Dan's bill? I'm gonna get us started.
Hi.
Hi.
1604, that's mine.
Awesome.
Has been, as you said before, for 6 years.
Right.
As it has been yours.
Yes.
You've been working harder on it than me.
We've had a lot of meetings on this bill, that is for sure. So I think we're ready. I do see that we've got a Jane Orbiton with their hand up, and I just want to make sure that's not a committee member trying to get back in.
It is maybe Andy Robinson. A number of people contacted me for links, and when I send it, it always comes out with my name on it.
Great. Yes. If we could bring in Jane Orbiton, which I hope is DA Robinson, this bill is on behalf of the prosecutors, as everyone knows.
Hi, all. Thank you for letting me join you.
Great. Thank you for being here, DA Robinson. Okay, Jane, I think we're ready to roll.
Okay. And Darlene, can you change Andy's name to?
That's what I'm doing.
Great. Okay. This is LD 1604, an act to reclassify certain offenses under IFW and motor vehicle laws and increase the efficiency of the criminal justice system. I call this the IFW bill, but that's really a very shortcut. The bill has been proposed to be significantly amended. And if you scroll down a little bit in the, we can see, I'll just give you a very brief overview. In Part A, it amends the IFW laws. In Part B, you can scroll, it amends the motor vehicle laws. In Part C, it deals with exclusion from evidence of evidence obtained as a result of an unlawful search and seizure, and it allows the issuance of a search warrant. In Part D, it gives jurisdiction to the Judicial Branch Violations Bureau. In Part E, there's an effective date of January 1, 2023. As we go further on to the, keep going, Darlene, and where we start seeing some boxes appear. What I did on this bill analysis was put in some boxes where there were issues, and in Part A, the judicial branch noticed some extra language that duplicates the authority of the judge already. and in Part B, the same thing. And my suggestion to you is, in order to resolve those issues, you could direct me in an amendment to just remove the surplus language. If we could go further into, there's another box here. The amendments in the amendments that have to do with the operation of the Violations Bureau are amendments that are, those comments are serious comments about the operation of the law, and I think you need some, you should consider getting some advice from the judicial branch or the Attorney General's office on how to structure putting authority for the Violations Bureau to handle criminal matters. You may or may not want to do that, but you may be able to get some advice about that first. There was also an amendment proposed to you from Senator Searway. Maybe Darlene, you can stop screen sharing the bill analysis and start screen sharing Senator Searway's proposed amendment. And his proposed amendment removes from the bill any changes in the habitual offender laws in Title 29A, Section 2551A. And I believe that there's been some input from other people on that. Also, Lieutenant Stevenson has had some input into this, and Lieutenant Bruce Scott sent me corrections on 3 things that are really just typos. So I don't know where you want to start, but I think the Violations Bureau authority is a big issue, and Senator Searway's proposed amendment is a big issue, and you probably have a few stored up yourselves. Thank you. That's all I have.
Thank you very much, Jane. I think we're good with the screen share, Darlene. Thank
Okay.
you.
You're welcome.
Senator DeChambeau, did you want to take over?
I was wondering, Joe Bill, you want me to?
That would be great, and I would like to, as the
Get some
sponsor,
water?
I have it right here.
Okay.
As the sponsor, I'd like to speak next, when you're ready for me.
Well, if you're ready, go right ahead.
I really don't know what happened there, but I seem to have recovered. Thank you, Madam Chair. Thank you, Jane, for that great bill analysis. Yes, we definitely want to deal with the technical drafting issues brought up by the judiciary. And if that needs to be done by a higher power, I can't remember, I know you mentioned the Attorney General's office, but whoever needs to do that before amendment review, that would be greatly appreciated. And I thank them for bringing forward those technical suggestions. Also, I want to thank all the folks that worked on this bill, and I'd like to remind the committee that you did have testimony in support from the Department of Public Safety, the judicial branch with their technical suggestions, the Maine Coalition to End Domestic Violence on behalf of victim services. You heard from Inland Fisheries and Wildlife. You heard from Maine Association of Criminal Defense Lawyers. You heard from the Secretary of State. All of these groups are in support of the amended bill. I'm sure there are more. You've got them listed here in your great bill analysis. I did receive the proposed amendment from Senator Searway. Jane sent it to me a couple of hours ago. Senator, we, as you know, when you work on a bill with many, many stakeholders, every change that we've made to this bill then requires multiple, more meetings, right? So somebody wanted something. And so then, let's say the folks, ACLU wanted to change. And so we'd work with that. But that then meant that we'd meet with the Department of Public Safety, and then the Department of Public Safety would meet with the governor's office. And then we'd then meet with the judicial branch, and then we'd have to meet with the Secretary of State. So I would politely request that we don't consider that amendment, simply because I have a group of stakeholders that I have been meeting with for years, and they have not had this amendment. I would like us to go forward with the bill as it's been drafted. But since I have put this in on behalf of the Maine Prosecutors Association, if he'd be willing, I would like to have DA Robinson weigh in on that, that proposal.
Thank you, Representative Warren. The amendment for striking B11 and B12, that's what we're discussing right now.
Yes.
And I think I understand what Senator Searway is trying to accomplish. He's making sure that the OASs remain in the triggers towards habitual offender, which is, I think, what would be accomplished if the amendment were allowed. One of the things that we tried to do is identify the suspensions, the operating after suspensions that we thought were linked directly to public safety. And you know exactly where we landed. We landed on, if it's associated with an OUI, that suspension needs to be a triggering event. It remains a Class E offense, and it was a triggering event towards habitual offender, the way that it's currently drafted. What we looked at was that in the existing statutory structure, the civil violations for OAS were exempted out in what is B12, but is Section 8 of the statute. It specifically said, hey, we're not including traffic infractions for OASs as a trigger towards operating after revocation. And so our model took that same sort of logic and said, okay, since we're now identifying the public safety concerning OASs as being the ones linked to OUIs, the others are becoming traffic infractions, they will be treated the same as existing traffic infraction OASs are under the current statutory structure. So that was our logic for it. And I think there's an elegance to it, right? I mean, the HO statute is a very powerful tool. And I think, Senator Searway, with your background in law enforcement, you know this better than most. It is the hammer that gets people to stay off the road. And that's why I think it's so significant that it really should be for those offenses where we're saying you being on the road is a risk to everybody else. And that's where that connection to OUI for us, we thought, boy, that's a solid connection. Some of these OASs are almost more bureaucratic and ministerial in their nature. It's almost like a status offense. And in that case, we wanted to treat them as we're currently treating those traffic infraction OASs. That was the goal and the logic of it. And use that powerful tool of operating after revocation for its intended purpose. And that is folks that shouldn't be on the road. Boy, there's a significant consequence if you are not adhering to the law after having been told to stay off. But we wanted to make that was, I think, the intent behind it. I like it this way because I think it's sort of it adheres to the theory of if you are a safety risk, you are getting treated as a Class E criminal for the original OAS linked to that OUI, and you risk becoming HO. If you are somebody who is sort of more of a status OAS, you are going to be held accountable. There's going to be a traffic infraction associated with it, but it doesn't ratchet you up or put you into that category that would allow you to subsequently be prosecuted as HO. That was the logic. And I can see your hand, so I should stop talking now. Please go ahead.
Well, I see Representative Morales' hand up first, followed by Senator Seaway.
Thank you, Madam Chair. And I move ought to pass as amended based on Representative Warren's amendment, given what we've just heard from DA Robinson. And thank you very much, DA Robinson, for that explanation.
And Senator Seaway. Oh, there's been a motion. I'm sorry. Ought to pass as amended. Is that one? Okay. Is there a second to that motion?
Second.
Moved by Representative Morales, seconded by Representative Pluker, and now we shall discuss that. And I believe Senator Seaway is ready to go right ahead. Senator Seaway.
Thank you, Madam Chair. I appreciate, what you've been working at, and I've talked to, many law enforcement agencies and some of this they agree with, and actually most of it, because it takes the burden of proof off and that sort of thing. But I did talk to public safety, and they did have concerns about the OAS, because you're actually having somebody operating that does not have a license, really. And it's a very dangerous situation where they may not have ever had a license. In fact, I had one with 15 years driving without a license. And he ended up, causing a serious accident. And then he has no insurance, insurance won't cover him. This really is a problem. And so you get the habitual offender, they felt was, and this was advice from public safety, that we do this change. And so I'm very concerned if we leave this out. So I cannot vote the way this amendment is, but I probably would have if we could have changed this amendment to HO. And I think it's a shame that we have one situation which could really cause serious circumstances, and of even covering a person if they're operating after suspension or without a license, and something happens, there's no insurance is going to be protecting the people, the people themselves that are on the other side of this. And so we're really doing unjust for the victims. And I see what you're saying, but there's a lot of the victims people are being left out of this. It's fine through the courts and all that, but the victims I'm concerned for.
And Senator Seaway, is it appropriate for me to respond?
Sure. I mean, that's up to the chair.
Madam Chair, would it be appropriate for me to just respond to Senator
It's
Seaway's?
been decided. Yes, go right ahead. No, really, I want to hear that too.
Let me, I would suggest to you that the Department of Public Safety has already testified in support of this version. And that was after having discussions, and God love them. To your very issue, they were thinking the exact same thing you were issued. One of the violations that we did not make a traffic infraction involved the individual that did not have insurance, because they cautioned us to that very fact pattern. So and I forget the sequence of factual events that triggers the provision, but there's a specific provision in the 29A that if you are operating without insurance after having been told to get insurance, it's a misdemeanor offense, and it remains a misdemeanor offense. And it was because Department of Public Safety told us this is the provision that leaves the victim of an accident, or when somebody has a collision and the other person was uninsured or underinsured, like they were more than they were supposed to be, we need to have a mechanism to enforce it. And so we left that as a crime. And I can find that provision for you because it was a very specific conversation we had. The classification of being suspended, we often make this nuanced distinction in the court. You if you are suspended, it means you did get a license, you passed all the exams, you know what you're doing, like how you're supposed to drive a vehicle. You're suspended for a myriad of reasons, which you know as well as I do. There's a lot of different things. And so that's not the thing that I think jeopardizes the safety. That status offense. One thing the Department of Public Safety communicated to us is, hey, if the person isn't qualified to be operating or they never had a license, then that should remain a crime. And we did that also. So in that fact pattern that I think you have in your mind, and rightfully, you're thinking about people that are affected by operators on the road and their status. If the person's operating without a license and they've never been qualified to operate, it's still a crime. If the person's operating without insurance under circumstances where they've been told they have to have insurance, that remained a crime. And so what we try to do, and you've already heard me out on this, is hone it in on if you're doing something that's going to affect others or you're creating a public safety risk, we try to keep those crimes for the very reason that you're communicating it. But I don't think it was the status of being labeled suspended that makes that distinction. I think it's those other provisions that already exist that give us the mechanisms. And so our colleagues at the Department of Public Safety, I'm certain the conversation they had with you was very similar to the conversation they were having with us. And they were identifying for us the provisions that they said, look, it's important that these remain crimes because of the consequences to other people. And we heard them and we followed their lead on that. So anyways.
Madam Chair, just to follow up on that.
Yes, go ahead.
And they expressed that to me in your discussions that they went along with it. But after a while, they also said we really should have that HO put in because they should be held accountable after the third offense, and it really should be put back, the way it was. So they felt that it really should be put back. So I'm just putting in what I felt and also they felt. And I called Jane as soon as I got done talking to them. So anyway, that's where I'm at. I'm doing it for the safety of public safety. So thank you.
I have Representative Pickett and Representative Warren.
I think Representative Warren's hand was up before mine.
Not according to my list, but
Okay. She's shaking her head no, so apparently it wasn't.
No, but thank you, Representative Pickett.
My favorite DA to harass. How are you doing today?
It's good to see you,
Mr. Robinson. There's a song that has something to say about that, if I remember correctly.
First time I've ever heard about it.
Back to where we got to get. I've got some issues with the bill, and I want to run them by you. What you were just talking about with Senator Searway, the comment I would make and the question I would ask is that to get your license in a status of being under suspension, to get to that place, you have to have had a rather serious violation to have your license placed under suspension. Would you agree with me on that?
Well, it depends. Do you consider not complying with a medical evaluation to be the serious offense? Because that would be an example where I would say, boy, it looks like a status offense. It looks like somebody should have been talking to their doctor, but it's not the same as sort of the serial violator. It's somebody with a health issue that needs to be conferring with a doctor. So there are some that if you have an OUI and you have a suspension, I wholeheartedly agree that it is. And there's places in the between. And I don't know if you have specific concern, like examples of, boy, this is how this person got suspended and this is what we're talking about.
All I'm saying is that, and is that when you're under suspension, there's a reason for you being under suspension. And And it usually is something that, you know, there's a reason why your ability to operate a motor vehicle has been stopped. And I understand that what you're trying to do with the bill and changing it. And I can understand your example you just gave. And the OUI is the example that was given before, and there's others in between. But at some point, after you get under suspension, regardless of what got you there, if you violate that and you operate under suspension again, and correct me if I'm wrong here, but under the bill, if you violated and drove under while you were under suspension again, then that would be a civil infraction rather than a criminal infraction, unless it had to do with the OUI.
Yeah, no, you're absolutely right on that.
Okay. See, that's where my issue is. If you're under suspension, you shouldn't be driving, because there's somebody placed you under suspension for a reason, and you're under suspension if you were found guilty of that violation in the first place, because you have to first be found guilty in order to be placed under suspension, correct?
You
can be charged with it, but it doesn't mean you're going to be convicted of it. You have to be convicted of it.
No, there's a little bit of a difference here, because
I'm not talking about the administrative one now. I'm talking about another violation. That's what I'm talking about going out there and driving the car and getting stopped, pulled over by an officer for speeding.
Okay.
And your vehicle and they ask for your license. You either don't have it or you pass them a suspended license. I've had both things happen to me many times.
No, but are you saying so they're suspended for a points accumulation? You can be most suspensions, I think, are based on a administrative process, you know, like an SR-22, a failure to provide an SR-22, or failure to provide
operating without insurance, that kind of stuff. Yeah.
But you are adjudicated of having an OAS. If that's what if you're saying that they are then summons for a civil violation of OAS under the current structure, they have to go to court, be found to have committed the offense and adjudicated of having committed an OAS before they trigger the criminal version of an OAS. Is that, if you're saying that's how it's currently exists, that's absolutely true. That's correct.
And that's what I was getting at.
Yeah.
But I mean, I see both ways, but it's a matter.
Can I weigh in? Because I see it, and I know, and I actually, you and I, we have had conversations where I know you see, look, there needs to be a level of accountability, and I wholeheartedly agree with you on that, right? But remember what we're saying. We're not saying, and then you walk away scot-free. What we're saying is, now you're going to have to pay a fine. And just like, you know, in a traffic court, if you have 5 prior speeding offenses, your fine on your 6th speeding offense after adjudication is going to be higher, because the court's got some discretion on that. And the person who has the prior OASs for civil violations, the court's going to be able to take that into consideration. And at some point, it's going to be prohibitive, right? Because you're just racking up your fine levels in your bills.
But under the bill process right now, though, those particular violations of operating after suspension that be termed as a civil violation, how does that work? And how does that work under the bill that we have in front of us here? How does that work in relation to that going toward getting you to the HO violation?
Yeah. If it is not related to an OUI suspension, it's not going to trigger HO.
It's not going to trigger it, and it's not going to be held as any part of becoming an HO, correct?
I agree with that. That is true.
I have a problem with that.
But Representative Pickett, there is already the civil violation version or the traffic infraction versions of OAS. That's currently true. Like, if you go and look at HO today, it specifically exempts out the violations that were for, failure to pay a fine. You remember the one they broke out the 3 that are civil traffic infractions and said, we're not using these as enhancements for OAR. So that exists today. And then
Okay,
the
those-
criminal convictions were being used to enhance the OAR.
Okay, so that's the point I was getting at. So those have already been dealt with right today. That doesn't even apply to what we're talking about today, then, is what you're saying.
Yeah, if you
The
left
civil violations for failure to pay a fine and that stuff. That's already in law right now, correct?
Yeah, it says, look, if you had an operating after suspension for failure to pay child support, one for failure to pay a reinstatement fee, or an adjudication for a traffic infraction, then it would not count towards OAR. That's the current law. And what we're saying with this version is we are now leaving the criminal version of OAS as a trigger for habitual offender. But if it's a traffic infraction, it's not being counted towards habitual offender. So we're sort of following the same model that currently exists, if that makes sense to you.
Yeah, I understand that. Madam Chair, could I have one more question for him?
Yes, that's fine.
Thank you. Another part I want to just be 100% crystal clear on in Part C of the amendment. It excludes from evidence in a civil violation proceeding evidence obtained as a result of an unlawful search and seizure. And then it says it authorizes a law enforcement officer who has probable cause to believe that a violation of law has taken place or is taking place to apply to the court for a search warrant. So putting those two things together, can you explain each one of those to me? I think I understand it, but I want to understand what the bill is trying to say about it.
Yeah, the bill has two purposes. Currently, under the current law, if you have possession of marijuana, you can get a search warrant for possession of marijuana, and you can do a motion to suppress for possession of marijuana. That exists in the current law, and essentially the legislature a few years back decided motions to suppress should be available to someone who has this civil violation of possession of marijuana, and officers should be able to search for it. Strike that. There's arguably a mechanism under the rules. No, there is a mechanism under the rules to get search warrant, but the law doesn't speak to it. So currently you have a motion to suppress for possession of marijuana that can be filed. When you change, especially under Title 12, a lot of the crimes to civil violations, the wardens still need to be able to go search for the moose meat or to be able to get a mechanism to go and see if the violation's occurring. We wanted to make sure there was no doubt they could in fact secure a search warrant to enforce the laws, even if they're just civil violations. In fairness, we also wanted to make sure that if a search warrant is obtained, there is a mechanism for someone to file a motion to suppress if they thought that it violated their constitutional rights in some way. So those two provisions are just making sure law enforcement can seek out a search warrant to enforce the laws, even if it's a traffic infraction or a civil violation, and law that the defendant or the person subject to the search warrant would have a mechanism to test whether or not the search was constitutional. Does that make sense?
So then if I'm out here and I pull somebody over and it is somebody that has some kind of a contraband visible in the vehicle, then does that give me the right at that point to secure that contraband and search the vehicle or not under this?
Well, you would, if you have probable cause to search, this statute gives you the ability to get a search warrant. And if you can get a search warrant, you can secure the vehicle until you can get the search warrant approved by law enforcement, by a judge.
But I can't take the contraband and search the vehicle and remove the contraband without getting warrant, correct?
Yeah, but I think that's true under constitutional law, right? Unless you have like exigent circumstances, you have to get a search warrant. This isn't designed to require a search warrant where you didn't need one before. It's to make sure you can get a search warrant when you need one.
So that particular scenario would still be what it used to be a long time ago, and that is, I ask the person if I can look into your vehicle and they allow me to look in the vehicle, then it's not, then it's a legal search, correct?
Well, Chief, you know this is better than most. That's a consent search. That's constitutionally permissible. No issues there. This statute doesn't change Fourth Amendment search and seizure law at all. It simply clarifies for everybody, the court, for the prosecutor, the DAs, and for defendants, that a search warrant can be obtained in order to enforce a civil violation or a traffic infraction, but the constitutional protections can be tested under a motion to suppress, just as it can be done in any. Anyways, that's what it does. It doesn't change any of the material laws surrounding Fourth Amendment search and seizure.
And that's important to me because I think Fourth Amendment law is good as it stands. And I just threw that out there just because I want to be sure everything is still intact like it was before. That's all.
That's the intent.
Okay. Thank you very much, Madam Chair.
And so ends the class on OAS. Okay. I will recognize, oops, where'd he go? I'm in the attendees list.
Representative Warren.
Yes, Sue DeChambeau was first, but that's okay. I may wait till all of you have spoken. So I have Senator Searway and then Senator Warren, yes. Senator Searway?
Thank you, Madam Chair. Would you mind if I brought up Lieutenant Bruce Scott?
Well, that was my question. Is he in support or I was trying to figure that out or?
Yeah.
So I will ask him though, Lieutenant Scott, are you going to speak in support or in opposition?
I'm pulling him in right now.
Okay, thank you.
So he may not have heard you.
All right. I think he's listening.
There he is.
Well, hello there.
Good afternoon, Senator DeChambeau.
It's Major Scott, right?
No, it's Lieutenant.
Okay, it's Lieutenant.
It's Lieutenant.
God, do you guys look alike? Okay.
We're identical twins. Sorry to do that to you.
Lieutenant Scott, I really was going to ask for you. I wasn't sure if you were in support or in opposition, but Senator Searway wanted to ask you some questions. I want to stay in support though, right now.
So, Senator, should I answer now or wait for Senator Searway?
No, we want to know. I haven't been able to see this.
Oh, okay, so the Department of Public Safety and the Maine State Police do support the bill as amended. And I did have a conversation with Senator Searway about some of his concerns, and that's where probably the rest of this is coming from.
So you're in support of the amendment you just heard, or I hope you did.
We are in support of the amendment prior to Senator Searway's amendment. I have not had an opportunity to vet this new amendment. So the prior bill that was introduced at the public hearing, we supported that based on our vetting process.
Okay. I still will turn it to Senator Searway, and so he's comfortable with that. You both have the same understanding. Senator Searway?
Thank you, Madam Chair. Yeah, I reached out just to ask Lieutenant Scott and also even the game wardens and also to because of our concerns from Representative Pickett and myself about habitual offender. And so I kind of felt that it was not reaching what we really need for public safety. So I guess in our discussions, I was just asking Lieutenant Scott how to go about this and what his thoughts were. And I guess between the two of us, I'd like Lieutenant Bruce Scott take it from there.
Senator DeChambeau, should I?
Yes, go right ahead, sure.
Yeah, yes, ma'am. So I think after talking to Senator Searway and addressing some of the concerns, the primary issue that came up during the public hearing and again during our conversation was how do you stop the repeated violations of OAS? And the concern was to continue to just write tickets without being able to make an arrest and remove that driver from the road would not stop the behavior. during that conversation, it started to become clear that the type of suspensions that he was concerned about was the automatic suspensions, like a 90-day loss of license for eluding a police officer, passing a roadblock, and then some of the suspensions that might come from leaving the scene of an accident, passing a stopped school bus, and the list was going on and on. How do we stop the behavior? And so that's where this idea came from, that if perhaps those types of violations counted towards the habitual offender status, they could be a traffic infraction to satisfy this bill, but they would count towards the habitual offender status should they continue to reoffend on that third offense within 5 years. And I know that's where Senator Searway was trying to go with this, but the state police and DPS did agree and support the original bill, the originally amended bill, sorry.
Okay.
Can I say just one thing on that? Do not forget, though, leaving the scene triggers operating after revocations. It counts towards operating after revocation. Criminal speed, eluding, all of those are convictions that will trigger operating after revocation or becoming a habitual offender. So those convictions, that conduct does move you towards being declared a habitual offender, absent being suspended for it and then operating while you're suspending for it. The actual conduct itself triggers habitual offender status. So, and Senator Searway, I just wanted to let you know that failure to provide proof of insurance, that's section 1605, section 6, subsection 6. That's the statute that remained a crime for failing to provide that insurance. So all of these behaviors that I think were just outlined by Lieutenant Scott are triggers towards having the person declared a habitual offender.
I'm going to recognize Representative Warren, and I want to be clear, Representative Warren, when I asked Senator Searway if he was all set, I said, okay. I did not recognize Mr. Robinson. He had his hand up, so I think Mr. Robinson thought I was saying okay for him.
I need to be better behaved. I'm sorry. I'm
Okay.
muting.
All right. Let's all, okay. So I know it's not intentional, Senator Searway, but I would just ask that we've had 2 days in a row where it sort of seems that we're unintentionally maybe saying that folks are in support or aren't in support and it sort of undermines, because it sort of puts on some of us that, like, now we have to prove that we're not telling the truth. So I just would like us to be really careful. I think that I presented that the Department of Public Safety is in support of this bill. We have had multiple conversations, as DA Robinson shared with you. Every single issue that has been brought up by any of the stakeholders, we have met, we have sat down, we have worked through the issues. So to then have, someone say that they're not in support, I would just like us, and I know it's not intentional, but I would like us to be careful with our words. It's very important that we're careful with our words. Secondly, Senator Searway, you bring up often the concerns of victims, the concerns of survivors. We all appreciate that. And so I want us to take a listen to the Maine Coalition to End Domestic Violence. They are the folks who represent a large portion of survivors, and they came and testified in support of this bill. I'm going to ask that you look at that testimony as well, but I'll read you a paragraph of it. Reform of our criminal legal system is both important and nuanced, and making good and right changes like the ones proposed in this bill often necessitate addressing unintended effects, one of which is noted below. Intervention by the criminal legal system is not a path that all survivors of domestic abuse and violence seek, but for those who do, it should work better, due almost entirely to resource constraints. Our criminal legal system currently struggles to, and there's a whole bunch of bullet points that they made sure they included so you'd have a chance to look at it, because we know that you have your eye toward hearing from the victims and the survivors, and we appreciate that. This is testimony coming directly from victims and survivors. And so I just want to make sure that you read their testimony. I think that to continue to say I'm concerned about the victims when you have testimony from the organizations that represent the victims saying they support this bill and here's why. We want the system to work better. We want the system to work more efficiently. We heard this morning that currently our courts have 27,000 cases pending. It's very difficult for survivors to get the remedy they seek in the courts when they aren't going to get a court case for a court date for well over 6 months. That is part of what we are trying to do here. I really want us to try to, when we say we care about something, and I know we all do, we have to then listen when those people talk to us. I hope that was clear. I'm not trying to be insulting to anyone, but I would like us to listen to each other, and I would like us to be careful about when we say someone is in support or not in support if we don't actually know that to be true. Thank you for the opportunity.
Madam Chair,
Go right ahead.
I just wanted to, I just thought that this was a work session and I thought we could amend bills. I guess I can't. So I guess I
This is a work
misunderstood.
session. This is a work session, and
I
if
guess I misunderstood though.
Oh, you didn't misunderstand. I don't like being, I don't like you letting, saying that somebody isn't in support of something when they testified in support of something. That has nothing to do with bringing an amendment. I'm not offended that you brought an amendment forward. I'm not offended that you didn't reach out to me. That's the way this business works. I have no issue with that. That's the way this business works. I'm not
I tried to
interested.
get this out to everyone.
Again, I have no issue with that. I just don't agree to your amendment, Senator. You did everything by the rules. Nobody is
Okay.
saying you didn't, but I just don't agree with your amendment. You absolutely can try to amend any of my bills at any time, and I will not be offended by that. I may not say yes, but you're using the rules appropriately. That's appropriate use.
Thank you.
Senator Seaway, that's why I called in the lieutenant, just to be clear, because I also heard they were opposed, they're for it. They got together based on other information they received. I frankly didn't know which came first, but that's why I'm glad Lieutenant is here to confirm that they were in support of the amendment. So, all right. So is there, I missed it now. If anyone made a motion, was that Representative Morales made a motion? As amended? And the second was Representative Pluker. I'm sorry, it was so long ago, I forgot. So it's been moved and seconded. Is there testimony? Okay, is there a discussion? We've been discussing it. Are you waving?
Representative Pickett has a question.
Yeah.
Or comment.
Okay. Go ahead, Representative Pickett. I'm going to make you all senators in a minute here.
I want to stay in the House.
We'll, I want to just pose the question, and I think it may have been the bill analysis. It may have been dealt with, but did all of the conflicts and things like that I believe it was Julie Finn from Judicial that she brought into play, have they been addressed or are they going to be continuing to be addressed so that we can have it for language? I don't know where we left that.
Thank you, Representative Pickett. Some of them will be able to be drafted. Yes, we are going to fix all of the technical issues, absolutely. My understanding is that some of them can be handled by our analyst and some of them need to be drafted by, I called it a higher power, but I meant the Attorney General's office possibly. But yes, we will make sure that all of the technical drafting issues brought to us by Julie Finn are addressed before the amendment review.
Okay, thank you.
Thank you.
Mr. Robinson, you had your hand up. Do you wish to make a comment?
Only that I did not understand when the committee talked about those technical changes. And then Representative Pickett, who I always think of as Chief Pickett, beat me to the punch, and he was thinking the same thing. So I think it sounds like we do have time to integrate the necessary changes and then get it back before the committee.
All right, so we're on board for a vote at this point. Everybody ready? Okay, Ms. Semino, you can call the roll call.
Representative Warren,
Yes.
Representative Morales,
Yes.
Representative Breckett,
Yes.
Representative Sharp is absent, Representative Lickner,
Yes.
Representative Pickett,
No.
Representative Costin is absent, Representative Brudnicki,
No.
no. Representative Newman is absent, Representative Pluka,
Yes.
Senator Lawrence is absent, Senator Searway,
No.
and Senator DeChambeau.
Yes.
Have 6 in the affirmative, 3 in the negative, and 4 absent. And is that going to be ought to pass as amended with Senator Searway's amendment, or is it
No.
ought not to pass?
No.
Ought not to pass?
Oh, you're there. Sorry. I thought
Theirs,
you were
yeah, no.
asking about mine.
Go ahead, Senator.
Yes, it'll be ought to pass as amended with the language that I had forwarded.
And I have a quick question. When we do the language review and everything, at that time, if after we have a chance to talk about this more before we do that, does the rules allow us at that time, if we chose to do a reconsideration vote?
We, on the prevailing side, would have to vote to reconsider, and I'd be happy to do that.
So I just wanted to make sure that was an option, because I want some more time to just
Sure.
dig through and everything, and to have a chance to talk with my caucus to be 100% sure. But I wanted to make sure I reserve that right if we got to that point.
Good question, and it's always an option. We just have to have the motion on the prevailing side, but we can do that together.
Okay, thank you.
Thank you.
Thank you. Thank you both, Lieutenant Scott and Mr. Robinson.
Thank you both.
All right. Our last one. No, almost last one. There are other little things we have to do. And 1897, and this is the work session on an act to prevent the use of prone and supine, that's a French word, restraints, chemical sprays, and electroshock devices on juveniles held in Department of Correction facilities. And is that yours, Mr. Tadikoff?
It is.
Okay, so we will have the legal analysis from the Office of Policy.
Sure. And I sent this around this morning. So I've listed the individuals and entities that testified at the hearing. I'm not going to go through them. The first bit of information I wanted to share was regarding the historical use at Long Creek of the measures that are proposed for prohibition in the bill. And so, as I've noted here, among those testifying on the bill, There was some disagreement regarding the use or frequency of use at Long Creek of the measures proposed for prohibition in the bill. Much of that discussion focused on 7 incidents at Long Creek in August and September 2021 that were analyzed in the November 2021 Center for Children's Law and Policy report. And I've broken down the information based on the techniques that or devices that are being proposed for prohibition. So the first is supine restraint, or a back down restraint. From the DOC's testimony, this restraint technique is not commonly used as it inevitably results in injury to the resident or staff. Neither of the CCLP reports, 2021 or 2017 report, explicitly discussed the use of or included recommendations specific to supine restraint. The other type of physical restraint noted in the bill is prone restraint, which is a face down restraint. Per DOC, staff are explicitly trained to use prone restraint only as a transition to regaining control and never as punishment. The 2021 CCLP report recommended that such therapeutic use of the prone restraint should not be allowed. The 2017 CCLP report similarly recommended that restraint of youth in prone position be prohibited. The next item proposed for prohibition was a chemical spray, referred to in most of the reports as OC, or oleoresin capsicum spray or pepper spray. Per the Department of Corrections, OC spray has been administered only a few times at Long Creek in the last 5 years. Only 3 classifications of staff, that total about 17 staff at present at Long Creek, are authorized to administer OC spray, and OC spray is locked in a special area of the facility and requires an authorization form to use. The Department of Corrections stated that the use of OC spray, while rare, results in less injury to residents and staff than the use of physical restraints when facing behavior that has escalated into property damage or aggression. The 2021 CCLP report recommends that the use of OC spray be banned at Long Creek, and the 2017 CCLP report similarly recommends OC spray be removed from the facility. The final item proposed for prohibition are electroshock devices, commonly known as tasers. Per the DOC, no officers at Long Creek working with juveniles have used these devices on a juvenile. DOC acknowledged that when its Special Operations, or SOG group, responded to one of the incidents over the summer in 2021, SOG members had these devices with them but did not use them. Per DOC, the SOG is no longer called to respond to incidents at Long Creek. There was conflicting testimony at the hearing regarding whether tasers have in fact been used at Long Creek, either during the 2021 incidents or otherwise. The 2021 CCLP report describes comments from Long Creek staff that the SOG adjusted its force interventions with use to, quote, just tasers and OC spray, end quote. Although the report is not clear whether tasers were in fact used at the facility or just carried by SOG members as indicated by DOC. The report, the 2021 report, however, does recommend that the use of tasers be banned at Long Creek, whether by the SOG or staff. That report also recommended the SOG not be used to respond to incidents at Long Creek. The 2017 CCLP report does not discuss the use or availability of tasers at Long Creek. I've included a short note here on the statutory placement of the prohibition. The prohibitions proposed in the bill are suggested for enactment within Title 34A, Section 3032, which is titled Disciplinary Action, and generally directs DOC to adopt rules describing disciplinary offenses and punishments in correctional facilities. Included under this section are provisions relating to corporal punishment, segregation, and monetary sanctions, to name a few. As suggested by DOC's testimony, none of the measures proposed for prohibition in the bill are used with a disciplinary or punitive goal in mind, but rather, at least in terms of prone restraint or OC spray, as a last resort to resolve a situation determined to pose a danger to residents and or staff at Long Creek. Accordingly, the committee may want to consider whether this prohibition fits within the general scope of Section 3032, or whether it would be more appropriately placed outside of Section 3032. The final note I have here is regarding the closure of Long Creek. As many testifying noted, the legislature last session passed LD 1668, a resolve directing the DOC to develop a plan for the closure of Long Creek and redirect associated funding to community integration services for adjudicated youth. The governor vetoed the resolve and the veto was sustained. Multiple individuals and organizations testifying on LD 1897 This bill expressed support for an amendment to the bill that would incorporate a similar approach to LD 1668 and direct the development of a plan to close Long Creek. Although there were many that expressed general support for that approach, two specific plans for that closure and associated activities were advocated, and I've included the details of both of those proposals, one from Maine Youth Justice and one from ACLU of Maine, although it was a sort of a coalition group proposal that included a number of other entities, including GLAAD and the Maine Prisoner Advocacy Coalition. I'm not going to go through those in specific detail, but I've laid out the scope of each of those plans to close Long Creek. The final note I'll say here is that we did get a preliminary fiscal impact statement from the fiscal office that indicated the bill as introduced will have no fiscal impact and that a fiscal note is not required. I'd be happy to answer any questions anyone has about that analysis or the bill.
Very well done, Dan. Thank you very much. Any questions from Mr. Todikoff? Clarifications? Okay. Representative Morales?
Thank you, Madam Chair. And this is just, you raised, this was a really excellent report too. Thank you very much. But you raised a point around rules and adopting rules around disciplinary measures. And I'm just wondering, this also for Ms. Orbiton as well, is how does the Department of Corrections for Juvenile Services adopt rules? Do they follow the Administrative Procedures Act? Are they major substantive? Have we reviewed that in the past in this committee? Just a question, I think, for follow-up from you both. Thank you.
Well, whether or not a rule is routine, technical, or major substantive would be indicated in the statute where the authority is contained. So I can't say one way or another whether rules under DOC that relate to juveniles are all routine, technical, or all major substantive. But if they are authorized by statute to adopt rules, they're required to comply with the Maine Administrative Procedure Act and the procedural requirements for rule adoption under that law.
Okay, thank you.
I've been helping staff criminal justice on and off for a couple of years, but I can't say whether or not the committee has had a discussion about that specific rule adoption process.
Okay.
Thank you.
I'll recognize Representative Pickett.
Yes, thank you, Madam Chair. I think we have in the waiting room, I think we have Christine Tebow and Amanda Wolford. They might be helpful in answering that last question that the good representative from South Portland, Representative Morales, asked. We might want to bring them in to have them respond to that.
I shall. Let's see.
Excuse me, Madam Chair.
Yes.
Generally, we hear from the sponsor before we begin our discussion.
Oh, I
He's got his hand
completely,
up.
well, you are correct. I was wondering. I will do that, and thank you for reminding me. Representative Lookner, please, would you, I'm sure you want to comment on what has been said.
Yeah, thanks, Madam Chair, and thank you for that breakdown, Mr. Tardikoff. I appreciate that. As long as we don't have any further questions for Mr. Tardikoff, I'd like to just give my thoughts after the public hearing. So if I'm okay to do that, if nobody else has questions, I'd like to proceed.
Well, you have a chance to comment on what was presented. And then as Mr. Representative Pickett just stated, he would like to have more information from the people who are in DOC right now working.
Okay. Well, I'll just thank you, Madam Chair. And based on that analysis and based on, you know, what I heard during public hearing, you know, it's pretty clear to me that, well, one of the things that struck me is that both advocates and the department are both seem to be in agreement that there isn't really a very simple statutory fix for these problems that are happening at Long Creek. That was one thing that I heard, as far as prohibiting the use of these techniques and the subsequent damage that is inflicted upon the youth at Long Creek. So that's what I heard. I also heard that a lot of folks are still very much in favor of a route to ensure that Long Creek is closed and that we're reducing the use of incarceration for youth in the state. As it stands right now, per LD 546 last session, we are currently increasing our capacity for incarcerating youth in the state of Maine. We're not decreasing capacity. So that's something I'm very concerned about. I don't have an amendment ready for today's work session, but I did hear those concerns, and that's something, I am very concerned with. So the direction I want to go, and this shouldn't come as a surprise to anybody on this committee or anybody listening in, is to set a date for closure for Long Creek. That's the direction I want to head with this bill. And that's what I plan to do. So just with that in mind, that's kind of the amendment that I will be offering. And so I just want to put that out there before we go into further discussion here. So, I've heard what everybody's saying. There are a lot of divergent opinions on this committee and within the department and the administration and the legislature about the best route to move forward. But I think if we're really trying to keep the youth at Long Creek safe, or adjudicated youth in our state, make sure that they're rehabilitated, making sure that youth in our state aren't subjected to institutional trauma-inducing settings, ensuring that everybody in our state remains safe by reducing the likelihood of recidivism for youth who end up adjudicated. I think the best route to move forward is to create a closure date for Long Creek. So thank you for hearing me, and I'm sure we'll have a lot of discussion around that.
So I go back to Representative Pickett's request to ask questions of.
Senator,
Yes.
I may not need to call them in, not that they won't be called in, but after hearing the good representative and what his intentions are on the bill, and knowing that today was the work session, and it appears as though that has been the closure of Long Creek has been the desire from the beginning of this bill, to get it into that posture. At this point here, I'm going to make a motion ought not to pass.
Second.
There's been a motion by Representative Pickett not to pass on this particular bill as written now, and second by Senator Seaway. So I will start with Representative Warren, followed by Representative Morales.
Thank you, Madam Chair. I didn't print off the commissioner's testimony, so I just want to be really clear that I'm not quoting the commissioner, but I'm paraphrasing his testimony that I was just rereading. I think the commissioner was really clear with us when we heard this bill that in his work, and the Department of Corrections runs prisons. That's what the Department of Corrections does. And he made it very clear that when you run a prison, you need to make sure that you have those tools available. And he is not, it does not suit the prison to not have access to the tools that they need. Again, I want to say, I'm not quoting the commissioner. I'm paraphrasing, and you can all check out his testimony on your own. And I agree with him. You can't run a prison without having the tools to run a prison. And when you're running a prison, unfortunately, that includes pepper spray, and that includes prone restraints, and that includes sometimes calling in the SWAT team. It's unfortunate, but it's true. And so that's one of the reasons that I'm going to support what Representative Lookner is proposing, is because it's true. We're trying to fix and make a place more safe for children. But the real issue is children should not be in a prison in the first place. And if they're in a prison, they're going to need to use these tools. Further, as I've thought back to the public hearing, absent of any of this discussion about the welfare of these children is the Office of Child and Family Services, is HHS. And for me, the fact that we allow, or the Children's Cabinet, or anyone in state government that talks and has the mission of protecting children, the fact that we allow a certain portion of young people, I'll call them young people, to not be protected by the very agencies that have the mission to protect young people in our state, I think it just became really clear to me that of course they can't. We've allowed these young people to be in this completely different place where they aren't even of interest to the Office of Child and Family Services anymore. They don't even come and testify when we're talking about using these tools against Maine's children. They just don't even weigh in. And I, again, everyone knows I do not have children. It's one of the decisions I've made in my life that I'm very happy about, but I care very much for all of Maine's children. And I wish that other state agencies did too, but it's true that when youth are in a prison, they are tended to by the Department of Corrections. And again, that's why I think we all supported Brennan's bill. I know that this committee supported Brennan's bill. We sent it to the governor signed Brennan's bill, and Brennan's bill said, we want to start to get youth out of here, and we want to replace the facility with these smaller facilities. But until we set a date to actually cease using this facility, all we're doing is adding beds as opposed to replacing. So for those two reasons, I'm going to be with Representative Lookner on the amendment that he'll be asking the analysts to draft. Thank you.
Representative Morales.
Thank you, Madam Chair. And this is a question also for Ms. Orbiden and Mr. Tartikoff about, we received a report from the department about plans to identify sites for two smaller secure facilities consistent with Representative Brennan's bill. And, it didn't dawn on me until this hearing that, while we support that, and I think, the department supported that, that if we don't have if say we have two sites and we open those two sites and we do not close Long Creek, then we are in fact increasing our youth prison system. And that really sort of just hit me with this hearing and all of this testimony. And so I'm wondering from that report, and I don't remember whether there was some timeframes in there in terms of when those sites would be ready. What we did hear, I remember from the commissioner, was one in Auburn was very ready to go. And I don't know if it's my memory, but that's what I remember of that. And so it makes a lot of sense to me that we look at that report, we ask the department where they are at, and that we do put something in place in terms of a date, because we cannot open facilities and start putting children in them when we also have children in Long Creek.
Senator Seaway, followed by Representative Pickett.
Thank you, Madam Chair. I'm concerned that this turned into from on use of force to now it's a bill that's totally different, and it's like a new bill. And the other part is that I'd like to, I think Representative Pickett had mentioned there was 2 people from DOC that was here. I believe there was 29 injuries, if I'm not mistaken, that the young people had caused. And that is a public safety issue. So anyway, could we ask one of them, like Christine Thibault, to come up and on screen and maybe talk to her about her thoughts on this?
I've given a lot of latitude for the kind of comments I'm hearing on a motion that is about restraints, chemical sprays, and what have you, and that the author wants one more amendment to come back that will probably say to close the facility. There is a motion ought not to pass on the use of restraints. So if I'm letting these arguments be said, if that sways anybody one side or the other, and I hope you understand where I stand, but I will allow it because this thing will die ever. And I'm not saying I want it to die, so we might as well just air our thoughts on that. So, but please be cognizant. It's confusing for me on not to pass what, or the people that wish to pass it.
Madam
They're
Chair, maybe
waiting
I
for
can
the
help.
amendment.
I might be able to help.
Go ahead. Yep.
If the motion is ought not to pass, when we vote it, the folks who want ought not to pass the bill will vote yes. And those of us who don't will vote no, and we'll just have our own report. It's the same that we do every single time.
Yep.
And I mean, we can bring more people in, and that's your prerogative. You're chairing right now. I think we've heard, as you said, we're going to hear the same things we've already heard. Maybe we could just vote it. We all know where we are. Or we could, spend the next hour hearing the same things we've all heard. And I'm happy to do that. I'm not really happy to do that. I want it to be done at 3, but if we have to.
My position is I have given latitude for the comments that were made when I kept looking at what is presented to us today. So I will recognize the people that have their hands up right now. So
Of course,
we'll
and I did not mean that our members shouldn't be able to speak. What I'm asking is, do we really need to have another public hearing by bringing in everybody again? Could we hear from our own members and then vote on the bill?
Representative Warren, what I heard Senator Seaway say that he does want to ask a few questions, and it's not a public hearing, it's just going a different way. I let you and others speak about the need to possibly, and you made some very good observation about other agencies, and there's a story there too. So I will proceed and finish, and let's be direct in our questions and also in the responses. So we'll go with Senator Seaway. Who did you wish to bring in?
Christine Thibault.
Okay.
Thibault.
Okay.
Should be on in a second here.
Good afternoon.
Yes, good afternoon, Ms. Tebow. Senator Seaway has some questions for you.
Thank you, Madam Chair. This amendment has changed quite a bit from what we were started, Ms. Tebow, and for one thing, what's your thoughts? And I'm against this bill because I think that there's been some big strides of 300 population down to 27, but also there's a safety issue. And I just wanted to hear from you what your thoughts about is getting a date for closure of Long Creek when we've gone through all this.
Well, thank you, Senator Searway, but I would not be responsible in responding to that question at this point. You know, this is something that we were not prepared to discuss that aspect of the bill. We are here prepared to address the bill as originally drafted, and we have information to share with the committee if that is the path that you're going to take. But if there's an amendment to be offered, we would prefer to wait until the amendment is drafted and submitted before responding.
All right, so what I'm asking though also is the safety issue. If we close it, well, you know, as far as the kids, I mean, young people, there is a safety issue, and we had, was there about 29 injuries to personnel?
Senator Seaway, I'm sorry, but I think Ms. Tebow did answer your question. They would rather make a comment when they were prepared to discuss this. Okay, so we're going to hold off on that. Yeah. Ms. Tebow, I should have asked you to identify yourself and your position within the Department of Corrections.
Yes, my name is Christine Tebow, and I am Associate Commissioner in the Department of Corrections, and I oversee the Juvenile Services Division. Okay, thank you. We're gonna, if I may, there is one piece of Senator Searway's question that I do have some information on that is relevant to the bill as drafted, if you would like me to offer that.
Go right ahead.
So in preparing for this bill and the public hearing and today's work session, we did a search of injuries to staff reported at Long Creek Youth Development Center, and there were 29 workers' comp claims. And I believe that has been over the past year, and that is staff who some were out for periods of time. Some I know from my own personal experience previously as a prosecutor have been out for well over a year now. So we do have that information. I believe that Ms. Black can provide that information with a little more detail if this committee so chooses. We're happy to send that to you.
Okay, thank you. So we have Representative Pickett and Representative Wernicke. Representative Pickett?
Yes, thank you, Madam Chair. I have a couple things that I would just like to say. First of all, we all know we had an opportunity to go and visit Long Creek. And I went on the day that there was 2 other representatives there with me. And I found the facility to be much different than what I had heard described in the committee over the years before. And I was able to talk, ask questions, and see what was going on. And I had the opportunity to talk with one of the residents there, and had this resident look at me and tell me that he don't know what he would have done if it would not have been for Long Creek to get him straightened out. And he told me the story, and I'm not going to go into it because I don't want to pinpoint anybody. But he told me the story while Representative Lookner was standing right there with me, beside him at the time. And he told the story of how if it wouldn't have been for the people at Long Creek and the work they had done from him when he got there in a very dark, dark place, that he would not be where he was at that point, that there was a lot of things going on in his life at that time, but Long Creek had, the people there had really stepped up to the plate. He didn't know what he would have done without them. I say that only because it paints a little different picture of what we hear of Long Creek every time we talk. And I want to remind us too, and I think it's okay to remind us that yes, there was full support in the House for Representative Brennan's bill, but that was after 1668 was vetoed and sustained. So it was not full support. It was in my recollection, and I could be wrong, but in my recollection, okay, that we were in support of it because the whole thing at that time was, let's get Long Creek closed down and let's get it closed down now. That's what was wanted. And then there was a strategic plan put together by the commissioner and by his staff, working with restorative justice and all those things, and working with different people to put a strategic plan into play, with the goal being to close Long Creek, but realizing that you could not close Long Creek immediately because there are residents at Long Creek that cannot be in a residential setting. There are, whether we want to admit it or not, there are. And there has to be a place for them as well. So therefore, because of that, we have to have a facility, which we have, that has worked really hard and even was commended by the CCPL report of how they had made strides in doing things. They're in the process continuing right now to make Long Creek a better place for these juveniles that are there. And we have gone from trying to take a look at what they're able to use in the facility when things do get out of hand, and what they may have to use as tools on their belt, so to speak. And what we want to do with them by the bill originally, I believe, is it would be like taking me when I was a young person and got ready to apply for the law enforcement, is to say, hey, we want you to go out and we want you to do the job. We want you to go out and we want you to handle burglaries. You might go to a bank robbery. You might go to a domestic assault. You might go to a place where someone's trying to beat somebody to death or whatever. But we don't want you to have a gun. We're not going to give you a gun to do it. It's kind of consistent with that as far as I can see. So we looked and we went through and we testified, and we all know what side of it we're on. But we also know that the people there in Long Creek do not take and go immediately to a taser and here or there and run in with clubs and stuff when anything happens. The situation that happened when those things were mentioned and stuff, that was when something really got out of control at Long Creek and really was going downhill fast, and decisions had to be made and changes were made, and we've already seen that. So my reason for moving this bill ought not to pass is because I don't want to take the tools away from people who do the job, because it's hard enough to get people to do the job today as it is. And I don't want to take those tools away from them when they're being trained in them and they're not using them in a wrongful way. They're using them only in a continuum of only what's necessary. And I support the commissioner 150% when he says, I'm not going to do that to my staff and put them in a situation where they do not have the tools to do their job. Thank you.
Representative Wernicke.
Thank you, Madam Chair. As I'm sitting here listening, first of all, I will agree with Representative Pickett on some of the things that he just said, because I think that is what it comes down to. If we look at this bill as what is presented and what the motion was made for, this bill is taking the tools away from the people that do the job down there that they need. And I think that getting off onto this other tangent of closing Long Creek again. If you wanted to do it again, you should have put a bill in specifically for that, as far as I'm concerned. But here we go, trying to do an end run around what's actually coming in, or hijacking a bill, or and the sponsor wants to add another amendment to work towards that. I think if we stick to just what we're looking at here, we give them the tools that they need, and we go along with that. And so this bill is an ought not to pass to me. And I will tell you, and as you already know, I'm against closing Long Creek, because I am against putting these young people, teenagers, into settings that could actually be detrimental to the people around them. They're in this facility for a reason. So that's where I'm at, and I will be voting an ought not to pass on this. Thank you.
Representative Reckitt.
I don't quite know where to start, but I promise you I'm going to be briefer than some of us have been today. I'm happy that that Christine Thibault is who I've known of and worked with for years and an admirer of. And I recognize that she is in an interesting position / difficult because she's fairly new to the position of Assistant Commissioner for Children's Services. And in reality, it is that position that has to have an overview on what's happening, not only now, what is in the process of happening and what may ultimately happen. And I think we make a mistake if we think we can solve the difficulties that some of us feel exist at Long Creek in a one fell swoop. I don't think we can do that. I agree and have agreed all along that the solution to the problems of having, what is it now, 27 or 26 young people in Long Creek, or 16, it runs up in that area, for frankly, what feels like a phenomenal amount of money to me. And I don't feel that's responsible to the taxpayers of the state. If in fact, the services that those young people need can be done in a safe and secure, a variety of safe and secure places, frankly, closer to their homes in many cases. I mean, there's talk of a facility in Bangor, I don't know where that one is, or Auburn. Both of those places, frankly, should have a smaller facility so that the young people can, in fact, if it's appropriate, intersect with their families. Because in the same kind of way that we talked about the women in the prisons having the opportunity to connect with their children, we're talking about families connecting with those family members while they're incarcerated in a way that is simpler than driving from Bangor to South Portland to see a child. So I think that it's, to me, that's a piece of this. And setting up smaller facilities, including a secure facility or two for those who are too violent to be left in a more open way. I don't want to insult my fellow committee members, but it's the same kind of argument you hear when you're putting mental health facilities or homeless shelters. People have to go someplace. I have a group home that's 2 houses down from me. It's been there for 50 years or 30. I don't know how many years it's been there because it has had no impact on me. But I know that it's there, and I know that there was a hoopla when it went in, but it didn't matter to me because the staff there that are dealing with the people who are within. So I think we have to understand that wherever it is we're going to put whatever facilities, they're going to have to be appropriately staffed. The treatment options have to be there for the residents. We have to be committed to the rehabilitation of these young people in the same kind of way we often say we're committed to the rehabilitation of adult prisoners. We just have to do that. And my belief is that, and frankly, I had no conversations with Representative Lookner on this issue, so I'm not speaking for him. I'm speaking for what I think ought be the way. In order to insist and get moving and move as quickly as we possibly humanly can to both design, plan, find facilities or build them so that we can have secure and more open facilities for young people in the state where they can be rehabilitated. I think in order to make that move as quickly as it needs to be, there is going to come a point where we have to close Long Creek because frankly, that's where the resources are right now. How can we build resource-rich, smaller facilities when the money is all going to Long Creek? That doesn't make sense to me. And I don't know how we do that unless we say 7 years from now on March 1st, we're going to close Long Creek, which I have no idea. I just pulled that right out of my head. It seems to me that if we have a vision for how long this is going to take us, and I think this planning process is going to have to guide us in that. I want DOC to tell me how long is it. I want Christine to tell me how long it's going to take us to get there. And then I'm going to add 3 years onto that and say, by that time, I want this facility that's in my city and that's in Victoria's district back in a functional use for the community, whatever we decide that is. So I would have no problem, whether it's to this session or next session, whenever it is, to say, I mean, in my head, if I were Christine, which I'm not, and somebody said to me, well, we got to have a plan, it's got to have a timeline, I'd be shaking in my boots. And I would say, you know, give me a little time to figure this out. I just got here. So if it's going to take 2 years for DOC to figure out what's this plan, what's the length of this plan, what are the things we got to do, then I would urge them to come back to us and say, we can't predict this right this minute. But in 2 years, I'm going to give you a solid prediction that we'll add 3 years to, and then we'll know that at that point, we're going to be able to close Long Creek. Because I don't think the Department of Corrections wants to keep it open any more than we do. But they want these young people to be properly served and rehabilitated. And I think that's what we all want. So anyway, I'll shut up now because I said I was going to talk not very much and I did. But that's if I could wave a wand, I would say, come back to us at the beginning of the next session. Tell us with a plan when you can close Long Creek, and we'll be with you and helping you get those facilities up and running, and we'll be all having the party together.
Representative Pluker.
Thank you, Madam Chair. And I just want to say thank you to Representative Reckett for those good, eloquent words. And I'm going to speak a little less eloquently now. I just wanted to say, you know, I've got kids in my house who've been in trouble, and I've got kids in my house who are likely to be in trouble one day. And I've visited Long Creek, and I don't want them to end up in that place when they're trying to get out of trouble again. And when I'm trying to act as a parent to help them move on with the trouble they've been in. And so that's why I'm going to support Representative Lookner here. I also just want to be clear that that the staff who are in this facility need our support as that happens. There's a lot of need within DOC right now, and we need to look at good places for those staff to end up so that they're serving the best function they can serve within the state. Thank you.
And I will ask Ms. Tebow a question. I agree with you also, Representative Pluker and Reckett. I think it's time to close Long Creek. It was difficult for me to vote last year. However, I also know about Brennan's bill and have had discussions with the commissioner. And I would ask Ms. Tebow, I know she's only been there a couple of months, but I think she's followed this closely. Could you just give us a very brief, not even an update, but where the Department of Corrections is right now with working on Brennan's bill?
Yes, Senator DeChambeau, I will. We are committed to the outlines in Brennan's bill, Part KKKK. And ironically, I had a meeting scheduled for this afternoon, starting at 3 o'clock, to meet with community stakeholders to help the department look at the places that we've identified as potential sites. That's a report that was given to this committee. I invited members of Maine Inside Out. I invited Mary Bonato from GLAD. Unfortunately, she wasn't available to meet today. I invited other stakeholders that are very familiar with running juvenile programs. I spoke with Katie Curry, who is our principal at Long Creek Youth Development Center. She raised some very legitimate concerns about education for youth in small facilities and how we would do that and how we would meet special ed needs for each of those students if we had small community programs. You know, we are committed to having this conversation about how do we build out a system that includes secure confinement, because the CCLP report was clear. There is going to be a need for secure confinement. It doesn't need to be in the configuration that it's in now, but we need to have a full palette of colors to operate with, and we need to have semi-secure programs. Earlier, Representative Morales mentioned our place in Auburn. We're scheduled to open a place beginning in April. We're referring to as Unity Place, which will serve multiple functions. It will serve as a step down for youth who are leaving Long Creek and are transitioning back to the community, but maybe they can't go back home right away. Maybe they need a few months before they go off to college, or maybe they're awaiting a more permanent housing situation, which we know is tragic for so many of our youth. But we're building out these resources to get youth out of Long Creek as quickly as we possibly can. We're committed to reducing that average length of stay, which was in CLP's report. I thank you for your very kind words, Representative Rackett. We do care deeply for all of these youth, and we want to have services that keep them close to their home, that meet their needs, but this is a very complex problem. For example, Ms. Curry was explaining that Long Creek is one of the very few correctional facilities for youth in the nation that can offer a high school education. Most places that have small community-based correctional facilities for youth are not able to offer a high school diploma. They can offer adult education, or they can now offer HiSET. And for those of you familiar with education, you know that those entities are not required to meet special education mandates. Long Creek does. During the pandemic, when a lot of students were disrupted from their special education programs because of distance learning, students at Long Creek were going to school every day with uninterrupted special ed services. These are the kinds of details that, as Representative Rackett pointed out, require a great deal of time, consideration. How are we going to put teachers for, let's just imagine a program in Bangor for 8 youth. How are we going to get a teacher there? How are we going to ensure that they have substance use disorder treatment? How are we going to ensure that all youth, regardless of their backgrounds and their religious needs and their cultural needs, are going to be served? This is a monumental task that we've agreed to willingly assume to build out this system. So thank you for the grace, Representative Rackett, of saying this is not a thing that we can do instantly. Staffing, as we know, is a huge problem for mental health programs. In fact, just this week, we learned that one of the contract providers who provides functional family therapy and evidence-based program for the youth that we serve is closing their doors because they cannot find staff. They have a program that requires 4 staff. They've been able to hire 1. That is not a failure of the Department of Corrections. We have the money, we're willing to give it out, but we need to have people to do the work. And when we talk about building out programs in different areas, we want to make sure that those youth have their needs met in that area. So yes, we are working on it. Yes, we are committed to the principles in Brendan's bill. Give us some time.
Thank you very much for that. One yes or no question. I was told that Department of Health and Human Services and the The Office of Family and Children's Services and Dr. Landry is also involved in your work. Okay, good.
Yes, we are certainly working with them. Alyssa Wynn and Dr. Landry and I have had conversations. They were invited to our group today to meet and begin discussing those potential sites. Hopefully they'll be able to make next week.
Well,
Yes.
we'll see. So we're going to move the question, the motion by Representative Pickett, seconded by Sairway, ought not to pass on LD 1897. Roll call, Ms. Simoneau?
Representative Warren,
No.
Representative Morales,
No.
Representative Breckett,
I have to think for a minute. Come back to me.
Representative Sharp, absent, Representative Blickner,
No.
Representative Pickett. You're on
Where'd he
mute.
go?
Yeah, he's right there.
Yes.
Representative Costin is absent. Representative Brodnicki,
No, sorry, yes.
Representative Newman is absent. Representative Pluka,
No.
Senator Lawrence is absent. Senator Searway,
Yes.
and Senator DeChambeau.
Yes.
Okay, I have three that are
I'm
going
ready
with the
to vote if
motion.
if you want my vote.
Oh,
on
I'm
it.
sorry. Representative
Um,
Breckett,
No.
no. Right, three ought not to pass. 1, 2, 3, 6. I'm assuming ought to pass as amended, and 4 absent.
I think there were 4 ought not to pass. There were 4 that voted no. So the motion was ought not to pass. And myself and Representative Morales and Representative Pluker and Representative Lookner voted no.
That's the side I wanted to be on too, Charlotte, so.
I thought you did, and Representative Reckett. So there are 5 no's.
Okay, look, I've got Pickett ought not to pass, Rudnicki ought not to pass, and Senator Searway. Who's the 4th one?
Myself.
Senator DeChambeau.
I put you on the wrong side. Sorry.
Well, it may have been the right side.
Well, are you going ought not to pass?
Yes.
That's- Okay. All right. So we have 4 that are going ought not to pass. 1, 2, 3, 4, and 5 ought to pass, and 4
Okay.
absent.
Yep, and 4 absent.
Correct.
Okay, that's Costain, Newman, Lawrence, and that's interesting. Who do we have? Are we gonna have Rachel Talbot Ross or someone else?
Representative Sharp
Sharp is on now.
is back on now.
A little different, okay.
Darlene,
All right.
Darlene, you need our report. You don't have our report.
No, I don't. Well, I do. Is it ought to pass as amended?
Nope.
Nope. Ought to pass?
Can you let the sponsor give you what his report is?
Okay, yep.
Madam Chair, am I good to go?
Go, of course, I'm sorry, go ahead.
Thank you, Madam Chair. I'd like to go ought to pass as amended. I need time to meet with DOC and meet with Representative Brennan and just kind of discuss, the timeline so I can lock down what I would like to see as a date. So I'll get that to you in writing.
I think that's great. I appreciate that. Mr. Tadikoff.
I do need the parameters of an amendment at least spelled out at the time of the vote. That would be consistent with the requirements in Joint Rule 310.
Okay,
His
so
report. Do you want me to do it, Grayson, or can you?
please, yeah, please, I defer.
I think Grayson has been trying to say this whole time that his report is going to be to strip and replace the bill and set a closure date for Long Creek. He would like to speak with Representative Brennan, who has the Brennan bill. He'd like to get an update on what those dates are, and he'd like to speak with the DOC commissioner before he puts a final date in. But that's what the amendment is. That's what the report is.
Just to be clear, do I have the authority from those on what's now the majority report to work with Representative Lookner on developing that amendment? Yep, okay.
I guess at this time, you got 5 votes to our 4, but we don't know what the others are gonna be. So I'm not sure we know what the majority is gonna be on this yet.
Right, whoever votes, we'll see if it's the majority report or the minority report. You're right.
We all set?
Yeah.
Thank you, Ms. Tebow.
So could I ask a question, just to make sure I know what we did? So basically what we've done is we've essentially eliminated the bill as it came before us, right? And instead we've substituted a bill that says we're going to close Long Creek, but we don't know by when.
Yeah.
Until we hear, okay, thank you.
Yeah, an end around to get Long Creek closed.
Well, that was not my
Well,
intent.
Mr. Tadikoff, this bill is dead, correct?
No. The only way you get a dead bill is a unanimous ought not to pass.
Oh, excuse me, are you up? Thank you. That's what we were voting on, okay.
And just so if anybody's, this is absolutely within all of the rules. This is absolutely what we do every single time we vote on a bill. Those who don't go along with the bill are asked what your report is. And you give what your report is. This is no different than that.
I just had a weak moment there, that's all.
I wasn't responding to you, Senator.
No, okay.
At all.
All right. So.
I know who you're speaking to.
Okay. It wasn't to you either. You want to keep guessing?
I will speak right now. I will close this meeting. We are done. Oh, no, we're not. We've got 2 language bills, do we? Mr. Tadikoff, I think there was, and it was Senator Stairway's bill on fireworks. Is that for Jane or was that language?
That one's mine. I can run through that very quickly if you want.
Yeah. Yep. Go right ahead. Thank you.
So I sent this out yesterday.
Yeah.
And this was the the unanimous committee amendment to LD 1348, Senator Seaway's bill about fireworks. The committee amendment changes the bill to a resolve to study the impacts of consumer fireworks use. You already reviewed what is substantially the same amendment at the work session where it was voted. The only item I would highlight here is the fiscal note, which is consistent with what the committee was told by the state fire marshal, in that his office, which is tasked with convening the stakeholder group and reporting back the results, can do that work within existing budgeted resources.
Oh. And that was the only thing right there? Okay, good. Any concerns, questions about what was just presented to us?
Looks good to me.
Okay. Not having done, we don't have to vote on that. It's a go, right?
Yeah, unless there's any issues, I'll go ahead and get it set to report out.
We're all set. Ms. Overton, was there another language? I thought there was another bill. No? So we're done?
The only thing you discussed whether you were going to work LD 1552 on reentry services next week or not, but I didn't catch a decision.
Senator DeChambeau, you were out.
I was here. It's just that I was doing something else.
Okay. Are you okay with us changing it to March 4th, just to give all the stakeholders a chance to meet?
Let me think real quick. Yes, I can do that. And yes, it's okay.
Thank you.
Thank you.
All right. We don't have a meeting till, can you just?
Friday.
Got to look. Next Friday, right? We have a session on Wednesday now?
Yeah, because it's a holiday on Monday and then it's a session day on Wednesday and then we have
What a nice.
Am I right?
Yeah,
Yeah, I thought we had 2 language reviews for today.
I thought so too.
I thought so too.
But we don't.
We
only
were
had
all
the one.
wrong.
Well, we're
I can
coming
do
back.
mine again.
No, we're coming back Friday. That's amazing. For the public, we're really coming back Wednesday, but Friday will be the next committee meeting. Jeepers, enjoy a few days and on a holiday weekend. And thank you, Ms. Semino, for helping us out.
Yes.
2 days.
You're welcome.
Thank you. Thanks, everyone.
Have a great weekend, guys.
Have a great weekend. Bye.
Bye.